Oop. Hello, everybody. Welcome to the planning board meeting Thursday, October 13th. Do a quick roll call. Nat Lowell.
Here.
Joe Topham.
Here.
John Kitchener.
Here.
Hillary.
Here.
Alternates, Stephen Welch.
Here.
Abby DiMolina.
Packet.
Is Abby online? No, okay. Howard Matz.
Yes.
Great. Staff members, Leslie Snell.
Here.
Meg Trudell.
Here.
William Sod.
Here.
And Catherine and Sarah.
Here.
Great. I would entertain a motion to approve the agenda.
So move. Second.
Motion made by Joe, seconded by Nat. Joe.
Aye.
Nat.
Aye.
Hillary.
Aye.
John.
Aye.
And I'm an aye as well. Okay, we're on to public comment for those things not listed on the agenda with a 3-minute limit. Welcome.
Oh, I'm going to pretend I have high heels on because I see those are all the rage. So I just have a question for the board, and obviously you're not going to answer me tonight, but anybody can feel free to just email me a response. So last Tuesday, I believe it was, we passed Article 1, correct? Correct. And one of the pieces in Article 2 that I thought was very important, but wasn't passed, was the piece about limiting subleasing of short-term rentals, whereby you rent it for 4 to 6 months and then you sublease that to short-term rentals. I thought that was really a very, very important piece to add. And I'm just wondering if there would be support for a citizen's petition that would advocate adopting that. So that's my one. Second comment is I was sad to hear that Pamela Perrin, who had introduced the Article 5 to the special town meeting before this one, is going to move based on the outcome of Tuesday's meeting, because she is surrounded by short-term rentals, and it's really disrupted her neighborhood and her sense of community. So I was sort of sad to hear that. And just on another note, coming over today, there was a bit on Venice, whereby Venice has lost about 120,000 local citizens that have moved away. There's about, but they are prospering with short-term rentals on Airbnb. So yay. Thank you.
Thank you, Campbell. Anybody else for public comment? Anyone online?
No hands are raised online.
All right, great. So we're going to move on to master plan inventory and assessment. Leslie, do you want to speak to this? Or?
Sorry, I didn't see it on the agenda, even though I did know we were going to talk about that tonight. So the master plan inventory and assessment was distributed to you, and it is just meant to be an inventory and an assessment. It's not meant to generate a lot of discussion unless, of course, you find things that are missing that should be referenced. So I would hope that you just vote to adopt it as written, but if anyone noticed anything was omitted, now would be a great time to let us know, but you could certainly do that later if something comes up later.
Because there's, my understanding is there's still plenty of opportunity for input from this board, that it's going to go through department heads and other town employees for input, and then it's going to circle back to us. So we're just looking to approve this and make sure we didn't leave anything out of the inventory. Is that?
Sort of. It was already distributed to other town
Okay,
officials and
but
to
we-
other town departments. So
but
they've
they're
had a
waiting.
chance. But again, if anyone notices anything missing, even after tonight, we can certainly add
Okay.
that in.
Yeah, I found it fascinating. I haven't been able to read the whole thing yet, but I read a lot of it, and I've just been making notes as I've been going along. It's just been a really busy couple of weeks. So I was wondering if there's any rush with actually adopting. I mean, everything's moving forward. I would love to be able to just take all my comments and give them all to staff. And I mean, I can do that anyway, I know, but I was wondering if
Yeah,
we should accept it. Give us a little more time to read it, because it's 127 pages and just had a really busy week, but.
But accepting it now does not preclude us from making those comments and ask for changes when we get back here, which will be in I think January is the time frame I heard, maybe, is that right?
Did we talk about the January? We don't have a.
We don't have
meeting
a hard,
scheduled.
okay,
Yeah,
okay, great, but we will get to it in not
yes,
too distant of a future.
Yes.
So,
Yes, and the public engagement portions of this plan are really focused on the vision statement, which already went through that public engagement process and was finalized, and the goals and policies. So the inventory and assessment piece is really meant to be more factual and not really left for interpretation.
so yeah, so I'd be looking for a vote to adopt it, and then we will have plenty of opportunity through the process.
We can't call it a draft, though, right? Even though we can make changes, we're not calling it a draft. I mean, I'm just.
This is just
being-
Well, the whole thing's a draft until the
Yeah,
plan's
well, okay,
adopted.
so
yeah.
that's kind of an
Yeah.
accepted thing. Okay, great.
It's-
That's what I'm trying to separate, a little bit, so.
It's just that it's an inventory, so, and it was prepared by consultants with a lot of staff input and a lot of staff time, and, board members have input too. So I haven't finished reading it. I will finish reading it, and I'm going to send my comments in. So whatever the board's pleasure is, as long as it's understood that, and my comments are going to be on, is there anything out of the inventory, anything I have a question about, or anything that I just think is in there that, like, for example, I'll give you an example, and this is really a detailed thing, but like it didn't mention the Fish and Wildlife area that's owned by the Department of the Interior on the island. Just little things like that I think they probably want feedback on.
Yeah, well, I think the important thing is to know that just because we vote tonight to adopt it does not stop us from making changes in the future.
Thank you.
Yes.
Would it be the possibility of coming back on for comments? And I have comments
Yes,
as well.
yeah, we will have opportunities to
Yeah,
comment
so
in this
maybe
whole
that make it,
process. Yeah,
keep it on the agenda.
yep. Alrighty, so I would entertain a motion on this item, please.
So move, Mr. Chair.
Second.
Motion made by Joe, seconded by Nat. Joe?
Aye.
Nat?
Aye.
Hillary?
Aye.
John?
Aye.
And I'm an aye as well. Okay, on to the minutes. I know we have one member that would like to make an edit. Is there anyone else? No.
I had one.
Yeah.
Should I mention my
Yes,
edit?
please.
Yeah, so I had one request about the October 20th minutes, the sketch plan for 37 Somerset Lane. I just wanted to request, about 2/3 of the way through the comment, it says, board members seem to agree that with the layout and that it didn't conflict with the intent of the zoning bylaw requirements, which was designed, So I was going to request that we strike that because it's speculative, that we seemed to agree. I think the minutes should just say, did we agree, did we not agree? And I don't think I did listen to the recording and we didn't really discuss that. So I was just going to suggest that we strike that. And then it says, there was a brief discussion regarding, and I would suggest just inserting granting the exception to use an easement for frontage if the development included. And I sent these edits to Catherine.
Okay.
So if that would be okay with the board, I just asked that we adopt these without amendment.
Yeah, I think that just include that in the motion to adopt those edits on October 20th, if nobody has an issue with that. Oh, okay, so I'd entertain a motion.
Motion to approve with those changes in that one set of minutes, and the rest approved.
Great.
Second.
Motion made by Nat, seconded by Hillary. Nat?
Aye.
Hillary?
Aye.
Joe?
Aye.
John?
Aye.
And I'm aye as well. So that's unanimous. Okay, on to second dwellings. Pride Foundation 2 Trust, 166 Cliff Road. If nobody has any questions on that, I would accept the motion.
So moved.
Second.
Motion made by Hillary, seconded by Joe. Hillary?
Aye.
Joe?
Aye.
Nat?
Aye.
John?
Aye.
And I'm an aye as well. On to the A&Rs. I think I would like to, where are we with Clifford's?
Yeah, we need to talk about that one.
Okay, so I'd like to pull out, we're gonna pull out Clay Street, AKA 44 Skyline Drive, and I'd also like to pull out for board discussion Act 2022 LLC 20 Liberty Street. So I'm going to ask the board for a vote on 159 Orange Street Limited Partnership, 3 West Creek Road LLC, and Lori Gray, George McClellan, Amy Thompson Revocable Trust at 298 Pulpus Road. Do I have a motion on those two?
Well, I'm sorry, but I think 298 Pulpus Road has a similar, basically exactly the same issue.
Okay, I mean, I'm willing to pull it out. So let's,
pull it out.
okay, so let's, I'd entertain a vote on 159 Orange Street Limited Partnership, 3 West Creek Road LLC. Motion on that, please?
So move.
So moved.
Second.
Uh,
Yeah.
Yeah, motion made by Joe, seconded by John. Joe?
Aye.
John?
Aye.
Nat?
Aye.
Hillary?
Aye.
And I'm an aye as well. Okay, let's take Clifford Williams, Clay Street, 44 Skyline Drive first.
Okay, so, Mr. Chair, we did have a meeting with Mr. Williams this morning. He expressed a willingness to withdraw the application, but we have been able to confirm that in writing or from his attorney throughout the day. Billy, can you put the plan up? Just 1 second. All right, so I think the board knows that an A&R is submitted to the town clerk's office, and you only have so many days to act. So we don't have an opportunity to review the plan in advance. It comes in, and then we have to deal with it. So parcel A5, as shown on this plan, is intended to be an easement. The board talked a lot about this. It was part of the Clay Street subdivision. It was discussed by the select board, and the select board voted to lay that out as a pedestrian bicycle path. So we have concerns with this being shown as a separate identified parcel and not an easement within lots A3 and A4. Those are really one lot. And just based on the fact that, this was part of a subdivision, it has potential implications to the intent of the planning board and what the applicant has agreed to do and what the select board has requested. We would ask that you deny this application or deny endorsement.
And that doesn't preclude him from bringing it back.
No, he could come back in December, which is what we discussed. It's just unfortunate that we were unable to get confirmation on his withdrawal.
So that it won't have a negative impact going forward. Okay, great. Questions, board members? So I'd entertain that motion, please.
A motion to withdraw. 44 Skyline
Deny.
Drive.
Motion to
Deny, sorry.
deny or not to endorse.
Not to endorse.
Yeah, not to endorse.
Okay.
That's my motion.
Second? All right, motion made by Joe, seconded by Nat. Joe?
Aye.
Nat? Hillary?
Aye.
John?
Aye.
And I'm an aye as well. Okay. On to Act 2022 LLC, 20 Liberty Street. So this is a 4181L, and I have concerns about, and maybe staff can help us here, about, at what level, I don't know what the word I'm looking for is.
I'll help you.
Help me out here.
What level of shed means as a pre-55?
Yeah, what level of structure do we need to see pre-55 to consider it for a 4181L?
And Billy, could you put this one up as well?
A lot of pages to find a picture that we looked at. Oops. I remember staying with Eddie. My God, I found him when I built this house.
Sanguinetti's house? Why
I remember that name when I was a kid.
Okay, so there's not a specific definition for what constitutes a structure that's eligible for 4181L endorsement. The planning board has discretion, which we talked about at last month's meeting, to determine whether or not it's a substantial structure. In this case, I believe it's about 190 square feet, less than 200 square feet. I believe that some of you may have gone out to view the structure, and it's really, subjective on your part to determine whether or not it's substantial enough for 4181L endorsement.
Have we approved a 4181L based on a structure of this size before?
I don't definitively know the answer to that. I mean, in the past, the board has looked at, the condition of the structure. Does it maybe have electricity? Does it maybe have plumbing? Those types of things. But again, it's very much subjective.
Board members?
Can you talk about the case law? Has it been litigated? I mean, I gave a mini speech about this last time, so I'm definitely not going to repeat that. But
Yeah. I did not research case law in preparation for this meeting, but Megan may have done some research. She seems to be.
I do have the A&R handbook pulled up that references the Sitco case, which was a case that the planning board took a position that the structure was not substantial. But ultimately, what constitutes a substantial building is not clear. So it says a landowner may have a problem arguing that a garage, woodshed, or chicken house are buildings that would qualify under the 81L exemption. Since the Sitco decision, there's only been one other land court case that's taken a look at what is a substantial building. This is Taylor versus Pembroke Planning Board. The court determined that in order to qualify for the 81L exemption, the use of a building does not control the issue. But in this case, an 88 by 30-foot cement block building with its own cesspool and electricity that had been used to store automobiles and as a turkey farm, that was considered substantial. So again, that's not entirely clear direction, but that's the two cases that we have. And the Sitco case referred mostly about frontage too, so that's,
oh, really? That it had adequate frontage?
that it did not.
That it did not have adequate frontage, and what impact did that have on the decision?
It was overturned, Sitco was allowed to subdivide.
Even though it did not have adequate, okay, thank you.
Yep.
Mr. Blackwell?
Hello, Jeff Blackwell for the applicant, the owner. The definitive piece of information that allowed us to date this structure came from the assessor's office. And in 1954, this smaller structure was described as a garage, and it was assessed for taxation, and it has been ever since. I think in the absence of definitive case law, a common sense finding by this board is whether the assessor's office determined in the past whether a structure is substantial enough to be taxed for the tax rolls. I mean, in the absence of this, information, I think you wouldn't have you'd have a lot less cover in terms of making a decision on this, but common sense says if the assessors felt that it was substantial enough to tax, it's a reason for this board to vote for it.
Fair argument.
I have a question. Did the assessor provide a map or any other information about whether, because, that was a long time ago. And I think there needs to be continuity, right? Like it needs to be the same structure.
The tax records, as you'll see, are associated, this property is associated with Lucille Sanguinetti, who purchased this property in 1946. And this property remained in the Sanguinetti family until about 4 years ago, I think. So in terms of continuity, the historical record, which I confirmed at the Registry of Deeds, is very clear.
But there's not is there a photograph, or did that come up in your research, a photograph or a map? I hear your point.
There's a photograph
Who
in
would
the
have taken the
Go to
photograph?
Page 32.
I'm sorry.
There's a photograph in the packet.
From pre-1955,
57.
from 57. So,
Well, the structure appears on 1957 aerial photograph, but that doesn't, that's not a definitive. It only strengthens the assessor's record about the existence of the structure, but it's, of course, post 55, so.
Yeah.
thank you.
All right.
I mean,
I mean, if they're taxing it, that
which doesn't surprise me.
for me is kind of a tipping point. But I don't know how the rest of the board feels.
Mr. Chair,
Yes.
Stephen Cohen's hand has been up for a little while.
Oh, okay.
I-
All right,
Great.
go
You
ahead.
can bring him over.
Stephen, go ahead and unmute.
Welcome, Stephen.
Hi, thank you, Mr. Chair and Billy. I would agree with what Jeff said, but I would only follow it up by saying that, this board actually had this exact discussion back in 2011 or 2012 when 4181Ls became very popular. And, the line in the sand that the board was drawing was essentially garages were big enough, but the scallop shanties and chicken sheds and little things like that weren't enough. But as far as I know, garages have been used for 4181Ls for the past 15 years, and this one is essentially 10 by 20 is pretty big. So this is fairly consistent with what the board has approved in the past, and and I think Jeff's notation about the town considering it large enough to tax is also a very good point. Thank you.
Thank you, Stephen.
So the town also used to tax livestock. I mean, we don't know what the tax law was and what the standard was. I think we really need advice from counsel about how the courts would, about how to interpret the case law on this. Because isn't the idea of the law being that you don't want to disadvantage some pre-existing use, right? You don't want to disadvantage a lot that had, two dwellings that were used, you know, from before we adopted the Subdivision Control Act. We don't want to disadvantage them, but the courts have said that there is a standard based on substantiality, and we're sitting here struggling with like nobody to advise us as to, you know, no counsel of our own to advise us. I don't think the tax record is dispositive because we don't understand the tax records or what, you know, what was taxable. You know, all kinds of property is taxable. Goods are taxable.
And I agree with what Hillary's saying, but I've always worked from the garage as something I would count as a 4181L large enough. Chicken coops, sheds, et cetera, now, that's just been a kind of a standard I've always worked with, so I think that's why this application's here, but I'd like to get case law and see if we, like, but I, from my standard and what I know from all the years is that this would be approvable, but I'd like to hear from town council. Because I think we're gonna see a couple more of these coming. And we don't know, and we don't know how many, so let's kind of get to it now.
This runs that fine line between garage and shed. I'm not sure that,
Well, I think the garage or a carriage house, if you will, so to speak.
and I'm not opposed to getting an opinion from town council, but I think that, again, that's gonna be as clear as the bylaw, probably, right? Which is not very clear. So I'm not sure how the board wants to proceed.
Billy, could you put the pictures of the structure up and the inside of the structure? Thank you.
Page 55, starting, Billy.
So up on the screen, we have the front side of the structure, and they provided a number of detailed photos of the structure as we go down.
Mr. Chair?
Yes. Is that Stephen?
Yeah.
Yes, Stephen.
Yeah, hey, I realize alternates aren't sitting on these, but I'm curious if you take comments.
Yeah, please.
I guess for me, I just want to say it seems like there may be other litmus tests to be using. If pre-existing seems like a very clear litmus test. If it's size, there's two potential considerations. One is with respect to zoning, so that's local. And that is that if a shed is 200 feet or less, it is insubstantial enough to not count towards your ground coverage.
Yeah.
The other is under the Massachusetts Building Code, which is obviously across the Commonwealth. If a structure is 200 feet or less and it's not a dwelling, you don't need a building permit for it. That is to say, there are no building inspections. So just with respect, it's considered insubstantial enough to not require a building permit or building inspections. So I thought I'd mention those two as opposed to the pre-existing dwelling litmus test. Thank you.
Thank you. Is this 240?
I thought the survey said 190. Can you go back?
The assessor says 240, but I wonder if the actual survey, we should go off of that. So that has 190, which is under the 200.
And Billy, can you go back to the picture of the interior? Did it have a dirt floor?
Yes.
See that correctly?
Joe, when did real 2x4s come out? You know, right?
But this isn't, I don't think this is about, I mean, I think we can
No,
all agree that it was there, it existed
In
pre.
54, that
Yeah,
must have been
but
right around that time.
the question is this a substantive enough structure to be considered for a 4181L? I think that's really what we're
I know,
here
but
to
what,
decide.
yeah.
For me, is the Silkley, like it's a 4x4, that would be a typical, older standard that they used, and so it looks like one wall was rotten, whether it was a window or whatever, that got replaced. was that CMU style and the 4x4, to me, that was what kind of really dictate the age.
Yeah.
But it's not the age.
No
we're
warehouse
debating.
and plywood.
But it is, yeah, I know what you're saying, but that's the math.
Yeah, I think what we're debating is this
Well, normally.
a substantial
we're
enough
not
structure?
right on the edge like that, is what I'm trying to say. Usually it's
Yeah, I mean, this
older.
Yeah, I mean,
dirt floor, correct?
Yeah.
a garage can have an,
Less than 200 square feet.
I feel like the measurement discrepancy might be corner board versus foundation, which I could do. That could be the discrepancy.
I mean, I have a couple of other comments.
this is not a substantial structure.
No, but neither is 10's New Whale Street. I mean, I don't know. It's complicated,
Well,
this stuff.
that is not substantial because it has been
Just
allowed to
saying.
demolish. That's completely different.
When you
This
look
is-
at,
this
when
is
you
a
look at the
dirt
back of this,
floor.
when you look at the back of this shed, Joe, see the big real 2x4s back there? Did you see that picture? This shed's been added to. That's old, really old.
The ridge stops.
I saw that too.
I think the documentation said it would have been moved onto the site, so that's probably why it's
So-
older.
Because of, and I just want to make this sort of to staff and, a little bit here, is with all the scrutiny right now on this whole bylaw, zoning bylaw, whatever, that shouldn't affect us as far as how we would look at this right now, other than just being extra careful. I have no issue with checking with council and continuing it. It's been there for a long time, it can be
We
there for
can't-
another month.
we can't do
It's an
that.
A&R, we have to act.
It's an
right?
A&R, you have to act, so whether you approve it or
You can't
do not
continue.
endorse it, you cannot continue it.
But they
You
can
need to
come
make a
back,
decision.
right? Can they come back? So
They can come back.
if we deny it, they can come back. And in the meantime, maybe we could have
Not
some
on an A&R.
consultation.
If the board requests for us to request legal services, we can do that. But that request needs to be voted on by the board. But
Well, that's
either way,
kinda what
yeah,
I'm
you
saying.
need to make a decision on this application today.
I mean, for me, I think Jeff's argument is persuasive, but then Stephen's argument is also persuasive to me. So I'm personally stuck in the middle here.
I just converted one of these into, I just converted one of these into a remote living room.
But-
I mean, so it's like,
Oh, but that,
you know what I mean? Of
yeah, but the
age and everything.
garage that was used for that 4181L was far more substantial than this one.
No, almost identical.
Was it really in
Yeah,
size?
it's almost identical.
Okay, I mean,
The
that's what I
structure,
wanna
like
know.
the whole, but I would say there was more rot damage to this one. But when going back to that one wall, we had to replace a large portion of the wall, which is kind of sad. But I feel like this, and I don't know what the use of this is. If it's to be demolished, that's kind of sad, but I do think there is opportunity to be able to use this.
Yeah.
So that's where I'm like, that's where, for me, I thought it was substantial enough to be able to turn it into a living room. And now that's what he has.
But no one's preventing them from doing that.
No, but I'm
Yeah,
just saying that was enough for enough space,
Yeah.
powder room, kitchenette, like, he was able to get enough space in there. So this is something, to me, to Stephen's point,
But
that's
that
why I
was the remote living room. That wasn't the garage that
It was, no, it was a carriage house. And so the wood, so the
was a
two by
garage.
four were
and
on the ground. They literally did exactly
But
what
on-
this was, and they built over it and it was on the ground.
On that project, it was the garage and then was there a
It was a
carriage
garage and
house?
then it was, he just put a TV in it. And then we lifted it and turned it into a remote living room. So that's, to me, the standard of, like, it was able to be used as habitable space. I think a shed, a chicken coop, no, that's not habitable space. So this, to
is
me,
more than a shed.
would lean me on that side of the line to approving this.
All right.
So,
Well,
If I may
please.
comment?
Yes.
I would like to request to withdraw the application and give you some breathing space to explore rather than have a denial. So I request to withdraw the application.
That's fair. Board members? Okay, someone would like to make a motion? Well, before we make a motion, time out. What what are we gonna do with this time and space he's given us to figure this out? I mean,
I
we
would,
could ask for,
I would like to make
an
two
opinion?
requests. I'd like to be able to consult with legal counsel that's really familiar with this. And I would also, so there's a guy, I think his name is John Mitchell. In fact, I attended a training with him last night, and he is an expert on this stuff. And I'd like to maybe have a private training on, I'd like to maybe suggest that to our staff, and they can, look at who I'm talking about. So that then we get both like the legal part, but also what are other towns doing? What's the, what are other, all the whole gamut of considerations I think we could hear.
so, listen, I think what we should start with is a legal opinion from town council.
Yeah.
And I'm not opposed to your other suggestion, but let's start there.
Yeah.
And see where that gets us, and then we'll consider speaking to the gentleman you referred to.
Yeah, I can circulate that information to our staff.
Okay, great. So I would entertain a motion to withdraw.
So moved. Without prejudice.
Without
So moved.
prejudice.
Yep.
Second.
Motion made by Nat, seconded by Joe. Nat,
Aye.
Joe,
Aye.
Hillary,
Aye.
John,
Aye.
and I'm an aye as well.
Thank you.
Thank you.
There you go.
So we are on to the next 4181L, which is the Lori Gray, George McClellan, Amy Thompson Revocable Trust at 298 Pulpus Road.
So I asked for this one to be pulled out just because it's basically exactly the same situation, although it doesn't have the constrained land issues. But this structure, the documentation that we have is also an assessor's record that says it was taxed at $200 in 1954. And the photos are later. And I mean, the aerial photos are, many of them are extremely hard to read. I couldn't read them at all. And the house looks different too in the aerial photos. And the structure now is substantial, but that doesn't tell us. I mean, the whole point is, I think we're supposed to be assessing these based on what the structure was like in 1955 and earlier, and we can't know that. I mean, maybe if we had an affidavit or something, but I would put this in exactly the same situation. I don't know if anyone's here to represent. Oh, hello.
Hi, Sarah Alger,
Gotta look
represent
around
the
room.
applicant. Also,
should have
Art
seen that one
Casparo is on Zoom. If you could, he's got his hand up. If you could bring him over, he can share some additional information on the screen, some photographs. This is a substantial structure. Yes, it was assessed at $200. The house was assessed at $400, but that's like half the story, because it wasn't assessed as personal property or as a shed or as food or as a truck or any of those things. It was assessed as a garage. A garage, you've already determined, is a substantial structure. So we have a house and a garage. We also have a lean-to structure, which also existed pre-55 but wasn't taxed, and we chose not to make it part of our application because we didn't feel that it rose to the level of significant. But we did feel that the garage and the house were clearly significant structures that were in existence in 1955. They're on the aerials. They're in the assessor's records as both a dwelling and a garage. Their ground cover is significant. I think it falls in line with everything that you've done to date. And I think it meets the standard.
Sarah, how big's the garage?
Excuse me?
How big is the garage?
The garage currently 486 square feet.
486 square feet.
And the house is 618.
Okay.
Yeah.
I mean, neither of these structures, one is called Toad Hall, and the other is called, I think, Little Toad.
Yeah.
They're not gargantuan structures by any stretch. But the Sutherland family has owned these structures since prior to 1955. If I had known that you wanted affidavits, I certainly could have provided them from the Sutherland family.
I mean, Nat's been on this property numerous times.
Since 87. And that's just what it is right now. That house behind it is, they're both old, I can tell you that. The studio and the,
We don't have pictures of the garage, correct?
We have, I think we have current day pictures. I don't know that we have 1955.
No, yeah, I
the
mean,
garage is on the left when you pull in from Pulpus Park, right? Yeah.
Yeah. Well, when you're pulling, see, when
There's
you're
two ways,
pulling
there's
in
different
from,
ways to get in there.
yeah, it's from the Wauwinet Road, the garage, the Little Toad is on the
That's what I
left.
meant. I meant Walnut, I'm sorry.
Yeah.
Jeez.
Mr. Chair, if I can just say something quick.
Yes.
The aerials are really difficult to see. So
Yeah, no,
I
yeah.
had reached out to Holly Backus. She actually helped me. This was after I was able to post a packet, but I do have a picture on my cell phone, the 1940 aerial, which pretty much shows the front half of that house, the L shape, and then the garage as well.
Yeah. That's exactly how it is. That property.
And I don't know if you brought Art over or not, but,
why don't we,
Yes, art is
Okay.
over.
okay.
I could, Mr. Chairman?
yes, welcome, Art.
Thank you. So on behalf of the applicant, I could either share a screen if you wanted to see current pictures of it. We did, rather extensive research. I completely agree that the aerials themselves are, somewhat difficult to read, but, I think this is more substantial than simply a garage. And I understand, the needing to judge it from 1955, but I'd be happy to share pictures if you're wondering what it looks like now. It's old.
Yep,
Yeah.
it is.
I would like just to see a picture to get an idea of the size, to be honest with you. I know that, in the tax records, did it have the square footage?
Can you see that, Mr. Chairman?
I can see it. That is, in my opinion,
That's-
far more
that's-
substantial than the last one we looked at.
You haven't seen what's in it yet.
I don't want to.
Here's another view, propane tank, dirt serving the structure, and if that's helpful.
It's helpful to me. Thank you, Art. Board members?
Yeah.
So I think it's definitely more substantial than the other one, especially given that it has, utilities, and it looks like it has some kind of foundation. It has a entrance for a pedestrian. I would still feel more comfortable if we're going to be revisiting this with the guidance of council, if the applicant would agree to withdraw and come back to us. But I also agree that it is more substantial.
On this one, to be honest, I'm not comfortable with that. I think the other one was borderline. I think for me, this one is far more clear. I don't know how the other board
I'm the
members
same.
feel.
Yeah.
I'm the same camp.
Yeah, so, with all due respect, I disagree.
Okay, I understand.
Board members,
Motion to approve as submitted.
okay.
Second.
Motion made by Joe, seconded by Nat. Joe,
Aye.
Nat,
Aye.
Hillary,
No.
John,
Aye.
and I'm an aye as well.
Thank you very much.
Thank you.
Sarah.
I think it would be helpful, once you have your training, if you could put together like a checklist of what you're looking for so that people aren't running into this at the last minute.
100% agree, Sarah.
Thank you.
Yes, thank you. Okay. I don't think we've ever spent so much time on A&Rs.
Wow.
We're on to previous plans. The first one is Fintry Lane subdivision. Mr. Dale.
Thank you, Mr. Chairman. Good evening, members of the board. My name is Kevin Dale. I'm an attorney, and I represent Karen Palmer. I was sitting next to her, who is trustee of the Fintry Lane Homeowners Association Trust, and also an owner of one of the subdivision lots at 1 Brayburn Way. The Fintry Lane subdivision is a small 5-lot subdivision off Eel Point Road, which this board approved on September 26, 1994. All of the lots in the subdivision have been released from the Planning Board Performance Covenant dated November 14, 1994, and they've also been released from the provisions of the Fintry Lane subdivision plan approval, which was attached to the Performance Covenant and registered at the Nantucket Registry of Deeds. In fact, that document was incorporated into the Performance Covenant. When the subdivision lots were released from the covenant and the subdivision plan approval, the subdivision was terminated. Now the staff has advised me they deem that to be a clerical error that occurred in 1994. It's been corrected since then for more recent subdivisions. All the owners of the subdivision lots want to regularize their titles to their lots by confirming termination of the Fintry Lane Homeowners Association Trust, the declaration of restrictions and easements, and the road maintenance and endowment agreement as a matter of record, because all of those titles reflect those documents. They also want the planning board to join with them and confirm this termination. The planning board has the legal right to terminate the HOA trust, the right to terminate the easements and restrictions, and the right to terminate the road maintenance and endowment agreement as set forth in the subdivision documents. I have submitted a proposed termination agreement for the planning board to review and sign. The planning staff has recommended that the board endorse this termination agreement. My client and the other owners, all of them, asked the planning board to vote to terminate the Fintry Lane Homeowners Association Trust, the declaration of restrictions and easements, and the road maintenance and endowment agreement, and sign the termination agreement. Once the termination agreement is signed by all of the owners and the majority of the planning board, I'll register that document at the Nantucket Registry District to regularize the titles to the lots. So, again, I ask you on behalf of all of the owners to sign the termination agreement and vote to terminate the subdivision.
Thank you, Kevin. Questions for Kevin?
So, Kevin, I don't know if we've ever done this, but I can see why this is happening. When you drive out there, it's like it's been there for, not forever, but close. But it hasn't. It's just, it's built into the whole area now. It's not like this is a new place that's separate from the rest of whatever. It sort of blends in with the other properties out there. And it's probably unnecessary because everybody is sort of knows what's going on out there in their little neighborhood. They don't have to have this legal homeowners association, so. I think it's their decision. You know what I mean? Like, I see it completely differently than if we were looking at like Gnaw Shop. If anyone tried to do this in Gnaw Shop, building would be on fire. But this is a different type of situation, So that's my kind of take on this.
But this is something we never do.
No, I know,
Right.
that's why I said that. I
But
remember
but the
doing it.
reason we're doing it is because the conditions that we put on this subdivision were unfortunately ended when their surety bond was ended.
Did they
They were
end last year?
connected together,
After
and so
30?
to end one, we had to end both, correct?
That's correct. Just to be clear, when the Form J releases were registered at the Nantucket Registry District for each of the lots, once they were all registered, the performance covenant terminated, as did the subdivision approval.
So we really have no choice here. I mean,
That is my view.
But this isn't a 30-year sunset till last year, right?
no.
Okay.
Well, they extended, right? So it says further extension of this deed shall be made prior to the expiration. And then it was extended last year, was it not? I mean, I'm actually really following the lead of my board members because this is unusual to me, but the questions I had were, one, it was all extended last year, and that restricts all of these lots to only one building. And that was all, it appears that was extended, so I guess I'm asking a question, what's the impact of that? And two, I'm just not sure who's going to take care of the roads.
They will.
Who's going to take care of the roads if this trust goes away? That was my other question.
I mean, listen, it's a,
Arrowhead Drive.
it's an encapsulated subdivision all to its own. So if their roads go bad, I'm sure that the neighborhood will come together to fix them. But Meg?
No, I was just going to say, the HOA being extended was a decision of the HOA that really had nothing to do with the planning board. The HOA is requesting to extinguish that. I would recommend you support it. Unfortunately, the way subdivisions were done in the 80s and 90s, it attached a list of restrictions that we now see in a decision to the covenant instead of having it as two separate documents. So it's an unfortunate situation where you have these lists of conditions that ultimately are meaningless now. So
Yeah.
bad news is pre-mid-90s, that's the way things were done. Good news is that's not the way it's done anymore, but, so that's why they're requesting the release.
So none of them are enforceable anymore, right? This is just housekeeping, basically.
Well, it's to regularize the title. Just to be clear, the subdivision wasn't extended. The declaration of restrictions and easements were extended based on the language in the declaration that said they should be extended, but the subdivision wasn't. As for maintenance of the roads, the owners out there have been diligent and have taken care of the roads. And frankly, the whole apparatus of homeowners association, trusts, everything involved is unwieldy and doesn't work for these particular owners. We've had difficulty getting a trustee. My client served as the only trustee out there for the past decade.
Yeah.
No one else wants to do it. So all in all, since in fact, as a legal matter, the subdivision was terminated in 1994 as a matter of record, I'm here to ask you to vote to confirm that termination so I can have the titles to all of these lots regularized so they can be marketable. So people can get mortgages and sell them if they want to. Right now, they're in limbo.
Yep, no, I totally get it. I understand. It's just we never see them, so I just wanted a little clarity. Board members? Questions, motion? I think we don't have anyone. Oh, no, this isn't public, so we're good.
I would make a motion to endorse the legal documents, terminate the HOA trust and the restrictions.
And motion made by Nat, seconded by Joe. Nat?
Aye.
Joe?
Aye.
Hillary?
Aye.
John?
Aye.
And I'm an aye as well.
Thank you very
Thank you,
much.
Mr. Dale. Have a good night.
Good night.
Good to see you, Kevin.
Always. Okay, on to Sparks Ave, minor modification of an MCD.
Good evening, Dan Malloy for the applicant. So this is a very minor change. So the Sparks Ave project is going through, call it final interior development plans. And when the buildings were originally, when it was one big building, everything worked. Now that it's two buildings and all the details are being flushed out, basically the arcade doesn't fit. It's part of the bowling alley, but it no longer fits in the building because they've been cut in half. So all we're looking to do is, in the permit right now, it stipulates where the arcade is located in Building A, which is the bigger building with the bowling alley. We're simply asking for a modification to allow the arcade to be located in the second building, which is Building B. No change in impact. If anything, by moving it over to the other building, we're actually reducing the overall scope of the project and what's in the uses, because the arcade is now going to remove what would have been a smaller restaurant space. And it will still be part of the bowling alley. We did see staff recommendations, and we totally agree that, and it was our intention anyways, the arcade will be part of and managed by the same entity that is the bowling. So we're fine with that as well.
Great. Any questions, board members?
Make a motion to adopt with the findings and conditions
Minor mod.
and my mod, sorry, spelled out in the staff report.
Second.
Motion made by Joe, seconded by Nat. Joe?
Aye.
Nat?
Aye.
Hillary?
Aye.
John?
Aye.
And I'm an aye as well.
Thank you.
Thank you.
Thank you.
Okay, on to 21 Amelia Drive, MCD. This is an update that was programmed into the decision. Welcome back, Sarah.
Thank you. Sarah Alger for the applicant. I'm not sure, I think one of my clients might be online, and Paul Santos is here with me, and I believe the wife of the person who runs the store is here
Great.
as well to answer any questions. Since this permit was granted, the store's been up and operating. We weren't aware of any complaints at all until, about 4 o'clock this afternoon, when I understand an issue was raised about a truck being parked on Amelia Drive. So we're feeling a little blindsided by that, because we literally have heard nothing in all the time that we've been operating, and it seems to be going really well. We think we're operating in conformity with our permitting. I guess the issue that was raised is the parking of a truck on either Amelia Drive or Waite Drive, but those are public streets. We didn't give up our rights as members of the public to park places. That truck, as you know, one of the concerns raised at the hearing was how would goods be delivered to the property? And rather than having multiple purveyors coming in and delivering to the property, this particular store owner has acquired a truck. He loads it up off-site, he brings it to the site. So it does come on site, as we said it would, to unload. That's how the store gets resupplied, and then it goes away. And sometimes, I guess, it's been parked on Amelia Drive. Sometimes it's been parked on Waite Drive. Sometimes it's parked somewhere else on his other property. Sometimes it's other places. But I think we're in compliance. I haven't heard any issues with traffic to the site, parking on the site. And I think that was one of the issues. Was there going to be ample parking on the site for customers and employees using the store? And I haven't heard of any complaints about that. And I think even the photographs that were submitted show that.
I agree. Board members, questions, concerns?
I don't want to, make the meeting, what time is it? That's not bad. So
Don't use that as an excuse, man.
Our time and your time. is
Sarah, that road, we're gonna be talking about till you and I are a lot older, okay? This is
I'm not
unbelievable.
sure I have a lot of years left here. but go ahead.
Because it's gonna take forever to get this widened, or whatever's gonna end up happening. But when we approve this, and we gave you this sunset thing, or whatever, we put this in here to come back and give a report, an existing operation that's got traffic, that has something going on, and another business coming in that's different, but we don't know exactly what's going to happen, but it seems to be an accommodating applicant. I remember they weren't going to do any sit-down, it's all takeout, as I recall. Is that true?
It's like a grocery.
I remember this
Yeah.
now
Sure they
pretty
do
well,
takeout.
or whatever
It's
it
not
was.
like, it's not a
no
takeout food
kids.
establishment.
No,
It's like a,
something that's not requiring people to linger around and hang out there.
No, no,
That's
no.
what I meant.
No
Whatever
hanging
that
out.
was. I know we talked about that.
We did.
But anyway, there is never going to be the perfect situation on that street. Cisco and US Park, right in the street to go to Meat and Fish, because some of the drivers don't want to jiggle in there with a pup trailer, which you can do, and I've seen them in there. But when you pull up after 3 hours of being delivered on Nantucket, and you finally get there at 1 PM, the last thing you want to do is get boxed in that parking lot and not make the boat. Like, that's what happens. Like, I mean, these guys are killing themselves to make their deliveries and get back off island. I see this as, there's going to be a few times where there's a truck parked there, but it's not every day, or it's not every time they get a delivery. It's probably, there's a reason that it happened that specific day that would never be able to be explained in this meeting, I can tell you that. So I think, other than today's a complaint at 4 o'clock or whatever time it was, I think we're doing okay. So that's my way of explaining it.
I think Sarah
Nailed it.
said it perfectly. We don't control where people park their cars on public roads. I mean, I ran a business in town for almost 40 years, and I used to bring my inventory in the morning in my van, bring my van home, and ride my bike back to work. And there was mornings I never got to ride my bike back to work, so my van was parked on the street somewhere. It's just the way it works when you're in business in this island, and it's not easy to be in
No.
business on this island. So I don't think that even though I appreciate the person that wrote the letter's concern, I don't think it's our place as a board to judge where this gentleman or where this business owner parks their car off their property. If it's not parked legally, then that's the police's issue. It's not us as a planning board issue.
and if there is an issue with this specific property, which I haven't actually heard that there is, but if there is, I mean, there is a mechanism for either you could let the staff know. Staff is very good about calling us up and saying, hey, you have an issue, fixing it. Or you can make a zoning complaint to Marcus. I mean, I'm not encouraging that, please don't, but, there are.
But this complaint wouldn't rise to meet any
Yeah.
of those concerns. I mean, if someone called the planning board and said, hey, this guy's truck's parked on Amelia Drive, the planning department would be like, call the police, maybe? I just don't know. And in all fairness to the person that took the time to write the letter, I just don't think there's anything that we can do in this application to address that.
Right, it seemed like maybe a broader overall issue than it was just this.
Maybe, yeah.
I had the same feeling that it's just frustration with that area.
Yeah.
And
Yeah.
all of the additional
to put it.
parking that's happening because of the much-needed housing in that area. I did notice that the owner wants to schedule the deliveries in such a way to minimize the impacts on parking availability along Amelia Drive. So I would just encourage, attention to that.
Yeah.
But obviously, I think this is working and it's great to have it in the neighborhood.
Yeah, and that fits exactly, I completely agree with what Hillary just said. Again, if it was a brand new, like, out of nowhere business that's replacing something that had very little traffic, and it was, gonna generate a lot more, that would be a different conversation
Right.
on Amelia. But in this case, I think we made a good judgment in this person's diligence to keep it at minimum, I think is a good example of working with the applicant and finding something that fits into these situations.
Mr. Sanchez tells me that truck makes one delivery to the store once a week at 10 PM on Thursday.
There's nothing in our power to control.
So we can all meet over there at
I
10.
could talk about loading zones all day.
Grab a box.
Grab a box or two.
Brutal.
All right, there's not a vote on this,
No.
I think.
This is just an update.
Yeah, I
It was
appreciate
just
the
an update.
update, and I hope they're enjoying good business and
Yeah.
it
Thank
continues
you.
to go well.
Thank you for
Thank
coming
you.
back.
Yep.
Thank you, and if there are concerns, please let us know as they come up.
We will.
I also think when we put on our NP and EDC hats, we can talk about her.
Yes. Don't get in that started, please.
20, it needed to be 28
So
feet.
on to sketch plan, 13 Woodland Drive. Mr. Maury?
Mr. Chair, I'm going to recuse. I live on the street.
Perfect.
Thank you, Mr. Chair.
Welcome, Stephen. Identify yourself.
Stephen Morey, 28 Rugged Road. What you have up on the screen here is a previously approved subdivision plan for the properties known as 13 and 13A Woodland Drive. Up for discussion here tonight, and I'm seeking feedback on this concept, which incorporates lots 5 and 6. I've removed the line between lots 5 and 6, but essentially it's the portion of these properties which are in the LUG2 district. And what you have before you is very literally a sketch plan. It wasn't done by any engineer. It is to scale. It does show 8 dwellings, 8 dwellings, each with 2 bedrooms. That was essentially to show what could be done within a combination of the number of bedrooms which have already been approved for septic and what is under review by the Board of Health right now. So 12 bedrooms have been approved for this site. 4 bedrooms are still subject to review and potential approval. The total site here allows for approximately 5,100 square feet of ground cover. A little bit less than that, 5,092, I think. So everything that's on this plan adheres to zoning in terms of ground cover, setbacks, things of that nature. What would be subject to your input and restriction as a special permit under the elder housing bylaw would be the total number of dwellings. And that's what I'm here to discuss, along with any other things that you think are worthwhile to discuss with regard to this proposal.
Great, thank you, Stephen. Board members, questions?
I like it.
I love it.
Love it too. Are we gonna see the deed restrictions, or is that gonna come later on? Just curious.
This is just, I think that's definitely
Just-
open for discussion.
You working on that?
Yeah, I think, I'd like to hear if there's anything, beyond what limited provisions are in the elder housing bylaw. It's not very robust, to be frank. It talks about limiting occupancy to persons age 55 and over. Feel a little embarrassed to even call that elder housing. But
Thank you for that.
Some weird rule. I'm like, I'm in. I know, I was
So,
like, what?
for me, I would love if you would explore at least a couple units having an affordability component to it with the Affordable Housing Trust. I think it would be a great opportunity. I like the sketch plan. I think it's a great idea. I think you're onto something. I think it would be great if we could figure out, or you and the Affordable Housing Trust could figure out how to come up with a couple of affordable units for these ancient people. Good thing I didn't qualify. And other than that, I like it, Stephen.
I had the same reaction, Stephen. It actually reminds me of, is it Massasoit Village out by Tristram's Landing?
Oh, yeah. Yep.
You know, the only comment, and this is totally up to you, you know, we used to favor cluster subdivisions, and I know they didn't really work out, but we did something like that with Wiggles Way, where you just get a lot of open space that can be enjoyed by people living there and passersby. And you bring people closer together, which if it's desirable for your community that you're marketing to, you know, might be something to think about. And so I just wanted to throw that out for consideration.
I think it certainly is worth consideration. A previous concept for this entire site was exactly that, the cluster, now the flex subdivision with consolidated open space. And this is, you know, a variation of that. It's very difficult to tell from this rudimentary plan here, but the idea is that people are parking near their homes, and then the homes are faced in toward one another and not toward the street. And not shown here would be, you know, walking paths between the green spaces. And I, you know, wouldn't imagine that we would be restricting access to that green space, you know, only to the residents. Certainly could be open to other people as well.
Maybe this is a question for staff, so these units will be on 2 lots, right? So where does that put us with concerns for ADUs in the future?
I think it's 1 lot.
It's 2. Is it 1?
Well, it's lots 5 and 6, but lots 5 and 6 on the previously approved plan
Okay.
would be merged into one.
Okay, so 1 lot, so there wouldn't really be an ADU. There wouldn't be an ADU.
It could have one
concern.
ADU.
Yeah, it could have 1 ADU.
And again, that would also be subject to septic and ground cover. So
Yeah.
if this plan is maxing out both, there
Yep.
would be no
No, and
ADU.
I don't have a concern with 1. I have a concern with 6. So, yeah.
I've heard you say that.
Mr. Chair, you have John Kitchener's hand.
Oh, okay.
Good.
Hey, John.
Talk about that.
Yeah, thank you, Mr. Chair. Hi, Stephen. Just a comment, Mr. Chair and Steve. I think it's really good to be seeing us acknowledging, you know, a section of our community that doesn't often get talked about, but this is going to be really, really beneficial, I think, to a lot of people on the island that will be kind of clamoring to be a part of this. And, you know, it may well be that some of these people, the homes they have right now, they may have homes that are a little bigger that may find their way back on the market for people that need that. So, you know, it might have, I think it's going to be great for you know, older people. And please don't ask me, Dave, about my age. But I think it's also going to have a knock-on effect that is also going to be very, very good. So it's great. Thank you.
Thank you, John.
John, I hope you're right about that. I hope this is an opportunity for people who are already on island to downsize and then make their properties available
Sounds
to
like you have a
year-round
listing
people.
opportunity with John.
Yeah.
Yeah.
Know
well,
where John lives. I don't think he's in
but-
danger of moving here.
Yeah. But not to prolong this kind of line of conversation, but you're right, Stephen, because if you look in other communities, what happens? People downsize and go to something smaller. Problem on Nantucket is people want to downsize, but there is nowhere, you know, to go. And now, you know, this might set the precedent for, a model like this might be, we might be able to do more of this. So it's great. Thank you.
The one thing I would add, and this is a mutual friend Dave and I have, is he's been going out to the Hayes property, and he said that surface is so good for walking. So if you could be mindful of that, because that is one thing, the daily exercise, get out, walk the feet, walk around. And I love Hillary's idea and there's one of my best friends, his mom and dad moved off island, and all the houses, the back door, and everyone went in the backyard and walked around and congregated and had a community. And I think that that's something, as we get older, is having that, connection to our friends and not being able to drive and et cetera. So I think this will be really beneficial, and I think it could work really well. So
Yeah.
Thank you.
it's a great,
I'll look at
great
that.
direction.
I agree.
Dave?
Yep.
Okay, great. I'll
Get
be
what you
back.
need.
All right,
right?
Good luck.
thank you.
Awesome.
Thank you,
Thank you,
Steve.
Steve. Good job on this. All right. So we have a number of continuations that we're going to continue to our 12,
December 8th.
12/8 meeting. We'll do them all at once. So it's LNB Rider 16 Bayberry Lane. Maryland Homeowners Association 9 Korea Lane. Longfin LLC 1 Bernard Valley Road. Fairgrounds Road LLC 25 Fairgrounds Road. 3 Yawkey Way LLC 3B Yawkey Way. All of these we want continued to December 8th, 2025, and I would.
So moved. Second.
Motion made by Nat, seconded by Joe. Nat.
Aye.
Joe.
Aye.
Hillary.
Aye.
John.
Aye.
Great, thank you. Guys still awake out there? Okay, next, Cliffside Beach Club, 46 Jefferson Ave. Mr. Brescher.
Thank you, Mr. Chair. For the applicant, the Cliffside Beach Club, Inc., Attorney John Brescher presenting. First off, thank you for hearing us. I know this application was originally submitted in May, and we have continued for a few months now. The main reason being the request before you is to boil it down, it's to allow for an increase in membership from 110 members to 140 members. 110 members to 150 members. The reason why we continued was to see the parking demand and to see how the parking functioned, to make sure that the beach club could handle an increase in membership and if it would impact the parking in any way. I want to first say that we took the staff report comments to heart, and just to give you a preview of sort of my concluding remarks, we will ask for a continuance so we can get a parking management plan together, and we're going to ask for some feedback from the board on what you think that may want to look like. I appreciate that this is a unique use, location, and parking configuration, and I'm not sure what templates there may be out there and what type of management plan you would like to see. I have with me Rob Curry and Chip from the Cliffside who can help answer questions as it relates to parking. But really going back to sort of the crux of the request, it's an increase in a membership from 110 to 150. And as such, it would be a modification to the existing MCDs. And as it stands, Cliffside currently has a courtesy car. They use valet parking. It's operational from June 21st through Labor Day, and they would continue to do that. And after seeing sort of the activity this summer and with the membership, we believe that we can meet that demand effectively. One other point that I really do want to add to this, which I think is important, is that nobody is more cognizant of the parking than the Cliffside themselves, because they're servicing as a club, and one of the amenities of the club is parking, to make sure that the members can get there conveniently and easily. And so if they thought that an increase in membership would be detrimental to the parking and sort of the functionality and the flow of the club, this wouldn't work. So they are cognizant of that aspect, and they are confident that the existing mechanisms that they have in place between the existing parking, the courtesy car, valet service, et cetera, can meet that demand. And as I said, we will plan on getting a parking management plan together. And I think sort of the purpose of today is that we're going to look for a little feedback from the board on what you'd like that plan to actually look like, given the use and given location of the club. And obviously, if you have any questions, you can obviously ask me or Mr. Curry and Jeff as well.
Thank you, John. I mean, I would take staff's recommendation on the parking plan. Put you right on the spot, didn't I?
I'm gonna actually defer to Arthur Reed, if that's okay.
Oh, okay.
He represents the neighbor, and I think he
Oh,
could speak more
perfect.
to how the arrangement works and kind of where both parties are at in terms of reaching common ground, perhaps.
That's fine. That's fine to have Arthur.
Let's hear it all. I mean, yeah.
By all means,
Arthur,
I mean, we are separate and distinct, but still conjoined.
totally get it, yeah. So,
Using the same-
are there any suggestions you have?
Yeah, let me give you a little bit of background on this. As you know, the Cliffside Beach Club and the Galley Restaurant have coexisted next to each other. They belong to members of the same family, and there's an existence, and has been for many years, an easement by which the Galley has the right to 13 spaces at all times within a 20-space area within the property that is owned in fee by Cliffside. And as both businesses have evolved over the years, with great success, I may say, it's been more and more obvious that the parking, regardless of any way you calculate the parking and any way you try to break the layout down, that the only way that this is going to work is with a joint arrangement as far as the parking is concerned. And that's been handled, as John indicated, for some years now with a valet parking system, which serves both businesses together. And the expenses and an arrangement and the contract on that have all been worked out on an annual basis between the parties. Now, my clients have no objection to the increase in membership that is proposed by Cliffside, provided that there is put in place an arrangement, a permanent arrangement, that so long as both of these properties are operated in the hospitality industry, that there would be a joint parking arrangement, which should be a contractual arrangement between the parties and also blessed by the planning board as a parking management plan. Now, we've actually submitted a draft plan a little while ago to Mr. Brescher and Mr. Curry. We haven't yet engaged in any dialogue about the specific terms of that. My understanding being from per my conversation with John today that it would be continued with input from the board and from me, and that at a subsequent meeting, this would all be presented in terms of a plan together with, whatever input is given by the board at today's meeting or is given after the meeting by staff, so that we can work out something that works for all parties. We sincerely hope that this can be worked out. We know that, I think we all know that the Cliffside property has been on the market. And I think that that underscores the need, since we won't have the same ownership potentially going into the future, that regardless of who owns either business, that there will be an ongoing arrangement to protect the interests of both parties with regard to the way that parking will be handled. The shared valet parking arrangement has worked, from my understanding, and my clients are also present at the meeting to give you any input that you may want from them. It's worked very well over the years. It's been in effect since I think 2012 or something like that, and it has worked well. It's enabled both businesses to manage what otherwise would be a very difficult parking situation, and for both of them to be able to go forward on a business-like manner that respects the interests of all parties. So in any event, we are committed to trying to work with Cliffside in order to have a parking management plan that will meet their needs, will meet our needs, which I think are quite similar, and will be approvable by the board. Thanks.
Great. Thank you, Arthur. So I guess what we'd be looking for is you all to memorialize the agreement between the two businesses in the business plan. Help us understand how the parking works now, how the I'm losing the word because I should be in that 55-year and older community.
Valet.
Valet, how the valet works. Total number of parking spots you have now. Anything else, guys?
Yeah, just a couple things. This is reminding me of across from Kitty's a long time ago, right? So, and all of a sudden it works now, right? This system works down there, but a lot of it has to do with people that actually know how to park cars without taking up 2 spaces, number one. Maybe we should get them downtown Nantucket. And also the timing of the businesses. That is the biggest thing. Like, if there were 2 restaurants down here that were open at the same time, we'd probably have some kind of bus parked somewhere, and, I don't know, but it wouldn't work the way it does. And that has to be memorialized and reflect the whole operation of how this place functions, is timing. So spaces are utilized because the people that are managing it know what they're doing. You don't want to mess this up just because they're trying to add some people. That doesn't mean that there's going to be 40 more cars with 40 more memberships at the same time. And I'm not saying there's not going to be an increase. I'm just saying it's almost like what the galley is doing isn't changing. It's been down there now for a while in that setup. And so is Cliffside, actually. So since it was the way it used to be, selling hamburgers out the side window and all that. So this is different now, and it works. So we just want to make sure that it continues to work without, going too crazy, at the same time being truthful about it.
Right.
So that's how I see it.
And a bad parking situation is going to negatively affect both the businesses. So you guys are going to do your best to make sure.
Exactly. I mean, that's sort of the assurance.
You're fairly contained there.
And I think that what may cause this a problem, I think they're all working together, it's great.
Yep.
But right across the other side of Jefferson Ave is the new land bank.
Yes.
And so that is not really controlled, so this could have impact. So I think if we hear concerns, we really need to be careful of what.
Well,
There are a lot of people
using
using that. This summer, I was down there this summer, and there was a lot of cars parking along the side of the road. So that's why I'm just we really got to be careful at how this is managed. It's not their concern. It's not the application. I'm just saying, zooming out, we might want to bring land bank into this.
That strip of beach is very popular amongst,
I
I'm
think
like
that-
really surprised when I
Oh,
go
it was
down there.
quick.
Your mom I see down there all
Yeah,
the time.
exactly.
Yeah, because you can
It's a
walk right
walkable
on.
beach.
People
to it.
walk, yeah, but you always could walk down there. It's
Yeah.
not any different than it was before.
No.
That's kind of a, whatever.
No, I mean,
I think
listen,
that's gonna
I think
find its own.
Both these businesses are
level.
good.
But I think that's
Thanks,
something
Bill.
they might need someone standing there for a summer or two and kind of manage it a little bit down there, but, yeah.
Oh, I have a question. So are you ever parking cars off the property? Is your valet ever? No, everything's on the property. And there was a note in the application about, this is in the way back history, so I'm just curious about the thinking behind it, that the planning board could require you to provide one parking spot for each 5 family memberships if we determine that the parking is not adequate. I was just curious about this concept of a family membership and what the thought process was for one parking spot per 5 family memberships, and if that's even relevant now? Is it ancient history?
If I may, my best guess for that is that again, this is this is a unique use out here, and I don't think it fit neatly into any parking calculations at the time.
I see.
And my best guess is they said, okay, maybe we use that as a barometer or as
Yeah.
a standard to try to capture what we think the actual parking is.
Well, I think if, as you said, if the parking doesn't work, you're going to be the group that suffers the most. It's not
Exactly.
a public place, really.
Right.
I think that for our due diligence, I'd like to know from the valet plan how many cars you can fit in there with the valet. And from your forecast, how many cars you think, this 36% increase in membership is going to generate versus what you have now. But ultimately, this is a negotiation about who pays for the valet, and that's not really something we can help with. So I think when you come back with your legal agreement and everybody's happy, as long as we've just done our due diligence to check to make sure we're not doing something really silly that we should have figured out, I think it'll be fine.
I think it is very important that all the parking is contained on the property. Yeah.
Agreed. And I think that's one of the attractive features of the beach club. I mean, that's one of the selling points that you can.
I go
park
down
in.
there often and rarely see the parking all being used. It's nuts, so.
Again, sort of anecdotally, we can back that up. So.
Yeah.
I mean, I could almost see like a daily parking pass or something they put on the windshield. They know they're there, as they come in and check in. You know what I mean? So then they also kind of monitor that.
Yeah, there's stickers.
I mean,
Yeah,
to
I know it's
Rob,
about stickers, but something for the day, because you just don't want everyone in there to have a sticker, because everyone's gonna think
I
they're
have a
parked.
feeling that the parking that the Cliffside uses is 99% their club.
Yeah.
And not their people that are staying at the
I agree.
the inn. They don't bring cars, correct?
Right.
Yeah.
Yeah, it's Nat's group that roll with their luggage.
Yeah, that's true, yeah.
Cases with wheels, man.
Clackety-clack.
What an impact they have.
I know,
on
I
society.
know,
do you
I'm
have a
saying,
pretty
this
clear
is
picture of what we're
this is
looking
where they're
for?
coming from now.
Mr. Chair, yes, I think we have a pretty good understanding of what we can, to the best of our abilities,
Yep.
bring to you, and what we'll do is we'll consult with staff to make sure this is that our visions match.
Great. Arthur, are you good with where we're heading here? Is he on still?
Have to click a button to unmute. Yes. Yes, I think we're definitely headed in the right direction. Again, I think the present situation works very well. And what we need to do is to put that more firmly in place in the decision, and I think we're headed in that direction.
That's what we're looking for. Great, thank you. So I would entertain a motion. Are we continuing this to the 8th of next month?
Sure. And if we need more time, obviously, we'll let you know
Okay.
with negotiations and contact with staff.
Great, John, thank you.
Motion to continue to December 8th.
Second.
Okay, motion made by Joe, seconded by Hillary. Joe?
Aye.
Hillary?
Aye.
Nat?
Aye.
John?
Aye.
And I'm an aye as well. We'll see you
Thank you
guys
all.
next month. Thank you. We are on to Graydon House, 4 North Water Street and 17 Broad Street. It's the Sarah Alger Show tonight.
This is a simple.
We like it.
Thank you, Mr. Chair. Sarah Alger for the applicant and, oh, yes, okay, Matt McEachern is here. He's the
Here's- oh, there he
project
is, yeah.
architect. And Garrison, who's manager? Chair, okay. And Paul Santos, our surveyor. So this is an application to modify an existing MCD special permit for the Graydon House at 17 Broad Street. I want to start by saying one of my favorite things, which is if these people didn't control Graydon House, we wouldn't even be here, because everything that they're proposing to do at 4 North Water Street could be done as a matter of right. They wouldn't need any approvals from this board at all. They could just go ahead and do the project. The reason that we're here is because we have an MCD special permit for 17 Broad Street, where Graydon House is, and we intend to manage these two properties as one because it makes sense just to be economical and run it as a cohesive property, and because Marcus Silverstein told me that I had to. And that's in reverse order of importance. So the proposal, it's pretty much working within the footprint of the existing 4 North Water property. There is a little bit of a bump out here and there. They're renovating that property, which previously had been just the most amazing offices and apartment space, but is going to be 4 guest rooms, employee offices, a library/lounge, and storage space. All the conditions of the Graydon House special permit would apply to this property as well, so we just carry those over. Those are attached to the special permit decision. I think someone had asked earlier if we had any complaints in our open log of complaints, and no, we don't. We haven't had any complaints. We're happy to say the operation at Graydon House has been, knock on wood, remarkably smooth, and I think has settled in very well in that neighborhood. And we're anticipating that this property will just kind of complement Graydon House as well. Happy to answer any questions, but I don't really have anything more to say. In accordance with the staff suggestions for conditions.
Questions, board member?
Good. This is the way things are now.
No, I mean, listen, I think the
Good.
Graydon House.
Fantastic.
Yeah.
Looks like it's been there,
Runs a
looks like
good
it's been there
operation.
100 years.
Yep, runs a good operation, and I have no doubt that will continue.
I think this is great.
Yep.
Layout, design, the whole package.
Yep.
It's great.
Thank you.
Very
So-
successful.
Make a motion to approve.
Wait, hold on.
Okay.
Yeah, you
Oh,
gotta close the
sorry
public
about
hearing,
that.
but there's no hands online.
Make a motion
No
to close
hands
the
on
public
that.
hearing.
Okay, there we go.
Second.
Motion made by Nat, seconded by Joe. Nat.
Aye.
Joe.
Aye.
Hillary.
Aye.
John.
Aye.
And I'm an aye as well.
Motion to approve the applicant's request with the findings and one finding and one condition.
Second.
All right, motion made by Nat, seconded by Joe. Nat.
Aye.
Joe.
Aye.
Hillary.
Aye.
John.
Aye.
And I'm an aye as well.
Great, thank
That
you
was
very much.
That was a rough one. Okay, next up, we are at Shampoo Landscape Realty Trust, 140 Old South Road. Welcome, Paul.
Thank you. For the record, Paul Santos with Nantucket Surveyors on behalf of the property owner and applicant, the Shampoo Landscape Realty Trust. This is a piece of property located at 140 Old South Road. It is a 10,134 square foot parcel located in the CMI zoning district. This parcel was before you, I believe, back in July, in which we submitted a preliminary subdivision or sketch plan, in which we combined, we showed basically 4 Arrowhead Drive and 140 Old South Road. So the plan that you see before you, everything in black is what this board approved the concept for of a preliminary plan, which was a 5-lot subdivision 1, 2, 3, 4, 5, which combined the Arrowhead Drive property and the Old South Road property. We're before you tonight to request a special permit to give us a different option or an alternative option for the development of, or the division of 140 Old South Road. So what you see in black is the way this was divided was Lot 4 and Lot 5. Under this scenario, we would divide in a similar situation, but in a basically north-south direction, if you would. There would be a lot here and a lot here. These lots would have frontage on Old South Road. It would give us the ability to create those 2 lots through an A&R or approval not required process, and not necessarily have them appended to the subdivision, which could act independently here with a turnaround coming out to Arrowhead Drive. It just gives us, the owners, another option on how to develop this particular property. So the reason we're before you is under 139.16, the intensity regulations, under exceptions to frontage, 139.16B1 states the following: the planning board may grant a special permit reducing the minimum frontage required in the commercial districts to no less than 20 feet, provided that the use or structure on the lot be granted such a reduction is a commercial use or structure, and that such reduction in frontage will not be visibly more detrimental to the neighborhood. So within the CMI zoning district, bear with me. I can't find that right now. The current frontage requirement is 50 feet. So what we're asking the board to do is grant the special permit to allow the 20 foot of frontage along Old South Road. We do not have a total of 100 feet. We have 71.38. We would be looking for a frontage of 3430 on one of the lots and a frontage of 37.08 on the other lot. This is a special permit that was previously controlled by the Zoning Board of Appeals. It was transferred to this board, I believe, at least maybe 1 or 2 town meetings ago, and that is essentially the request. This is not a request for a variance. It's not a request for a waiver. It's a request under an allowed exception to the frontage rules. And we're happy to answer any questions that you may have. We meet the criteria of a commercial use for these 2 particular lots. And again, it gives the trust the ability to look at potentially 2 ways to further subdivide this particular piece of property. Happy to answer any questions that the board may have. I'm not sure whether you've seen any of these yet since the transfer has been to this board, but like I said, happy to answer any questions you may have.
Board members.
Thank you, Paul. Could you explain just the access under this alternative proposal? Where would these lots
Sure.
be? How would these lots be accessed?
So currently, the Shampoos control both the Arrowhead and this particular property. But under this scenario here, the access would be on Old South Road. And under the scenario that we have, one like this would be a shared access at that point that already exists. You've already got the existing structure here. You have the one entry here. And under this particular scenario, more than likely, this scenario would act, if I did a 2-lot A&R, with cross easements, reciprocal easements between the two particular properties. And it would be an access off of Old South Road. Because that's where the frontage would be, would particularly be taken. Right now, this address is 140 Old South Road. There's your frontage, there's your existing driveway access to the property. And the structure is here.
And so with these two lots, then there would be two lots serviced by that or
I
similar
believe that would be the
existing.
intent, was to utilize that one particular, that one entrance with a shared easement between the two lots.
And what we approved before, Lot 5 would be serviced by, would be accessed by Old South Road?
Correct.
So-
And Lot 4 would be off the newly created subdivision, but we also did leave a potential access easement in this particular area by which you could potentially enter here and then cut through, which is now how the property
Right,
does.
that's what I was just
That's
gonna
what
ask you.
functions
So-
right now.
So you want to leave that potential?
Not necessarily.
Okay.
Again, it would be, see how they would potentially leave these out. I mean, I think the beauty of this parcel is you still have this building here. And even though they're divided by the middle, I'd suspect these would probably be, if this is the scenario that they go, the uses would still somewhat be divided the way that the original lots were, with just reciprocal easements between them. Again, it's just another option that they have to utilize. It's still two lots, it's just a question of how they would potentially be utilized. Quite honestly, if this scenario wasn't done this way too, I could still be asking for the same waiver, but if I decided to access strictly off the access road, I'd still need that same special permit because I don't have the 50 feet of frontage along the, for both lots along the proposed roadway.
I'm gonna say that again, if you cut those in half, why would you not have the same frontage?
Well, no, what I'm saying is if I didn't, either way, if I was gonna access the road, I'd still need this special permit because that's only 20 and,
Gotcha.
that's just 20 and
Yeah,
20 there.
sorry, I was kind of, thank you.
Yeah.
So, Paul, how you doing?
Good.
Good. It's always good to see you here. Arrowhead Drive, and I am not in the camp of one applicant should be doing all this work, but you're familiar with that road. I don't have to talk to you about the wooden curbing. I
Yeah.
love the wooden curbing. Don't you love that? It's sort of like DJ's and the town parking lot, with the spikes sticking up. Anyway, all right. What Plumbers just did with that concrete, pretty cool.
Yeah, that was a joint effort.
I
though,
know. Oh, no,
between
no,
Toscana
I know.
and-
That's why I'm bringing it up.
Yeah.
That road is still a private road. The whole thing with Coffin Pit, other things got fixed instead of that. Never gonna agree with that vote, but I went along with it, even though I didn't agree with it. But here we are, exactly what I kind of knew was coming. This area is not going away. That road is horrifying, okay, until you get to the new part. What about a joint effort, like everybody that's left? I'm not asking this applicant to do what Plumbers did in conjunction with Toscana. I'm just looking at, okay, half's done, or it's not quite half, probably like a third got done in that little plan. I think the whole entire neighborhood should be paying into the last piece of fixing it, because everybody's benefited from the Coffin Pit. It's been a great success in getting that done in the way it's turned out. But this little nugget here is like embarrassing. You know what I mean? And this is probably the last thing that's gonna happen other than whatever happens with the old Chevy dealer.
Yeah.
So I'm just throwing that out there,
Yeah.
so.
Well, I think you've seen just in this area recently, obviously the shampoos, but this was sold
Yeah,
recently. This has been cleaned up quite a bit.
it is. I know.
it's-
And
Josh Brown's in that
Yeah,
building now,
yeah,
and it's done wonders with that particular building there. They've gotten off the well, they're now on town water.
Yeah.
So, I mean, I think when this, if the subdivision here comes into fruition here, I think that's time to talk about maybe from here to the intersection, at least this
Yeah,
corner,
getting something.
getting a piece,
Yeah.
a piece on the way, you know what I
It's-
mean, so.
It's just Arrowhead got left out
Yeah.
of what we normally would have kind of requested back then. But the reason it happened beyond that, everything happened one at a time out there. The boatyard was later, the Yates Building was 91, Plumbers was 92. And then it just sort of putted along with a little at a time, and it just sort of ended up this way. And it was like one of those oil sand mix roads.
Yeah.
It just was, you know, nobody ever thought that road was gonna become what it is today. So I just think there needs to be a, you know, not a combined effort to finally fix it with, you know, everybody, honestly. So I would not put this on one applicant, the rest of it. I'm just talking to you as a, you know, somebody that knows what's going on out there. That's just, it's time to fix that road somehow.
Yeah.
Okay.
Any other board member comments?
I have a comment, but I'd like to hear what Campbell has to say.
Okay.
Oh. Sorry.
Campbell's gonna speak in favor.
She's circulating around, confusing us.
She moved her parking space.
Campbell, we're easily confused at this table, so.
That's all right. I think we're all going to like Stephen's new proposal.
There's nothing left of-
So I'm a little, I have to admit, I'm a little confused by all the lines on that drawing. Okay? So I understand, I think, from what Nat's saying, that 20-foot road is already there?
Yes,
And was that an approved 20-foot
just an entrance.
entrance,
Right.
like the reduced entrance? Or is it because it's being divided into two lots that it becomes reduced frontage?
The zoning just, I'm gonna let staff answer that.
Yeah, through the chair, yeah.
It's the CMI district allows that.
Right.
Well, each lot needs to have the frontage, and if it's subdivided, then he's shy frontage, and so
Well,
that's why
that's
he's-
what I'm sort of, and I get that it's CMI and you can do that. So my question is really in the foreseen commercial use, what is the size of the vehicles that are going to be going in and out of this? Just, of course, I live on a inappropriately wide road for what traffic occurs on it, and it just seems like it could get awfully cramped if you're having, some of the sizes of these commercial vehicles out there, or whether they would have like in one road and out the other. Do you see what I mean?
Yeah, no, listen, I think that this is an important discussion for us to have, is to understand what the use of these properties will be if we allow this. Will they be landscape contractors? Will they be, for me, I have no problem reducing the frontage, but I feel like I just don't have enough information about what the subdivision's gonna look like in the end, or what the use on those lots are gonna be. Does that make sense to you?
Well, the use is gonna be whatever's allowed in the CMA zone under,
Yeah.
without having to come to this board for relief.
Yeah.
You know what these are gonna be? They're gonna be commercial, these are 5,000 square foot lots that are attractive to a small landscape company
And it's
or a
already-
small,
We don't have enough of them.
that's what you're getting. Granted, a lot of these are out on Industry Road.
Yeah.
But you're in that same general area. And this is the way it operates now. This is all Shampoo Landscape. This is basically a landscape operation from Arrowhead all the way to Old South Road.
Correct.
Now,
So
138 Old South was a separate piece of parcel that was bought by the trust. And then this is all housing now for the landscape company. But that's what you're gonna get. You're gonna get a 5,000 square foot lot may have a building on it, may not have a building on it, and it's gonna be for that type of user that's gonna be there. Now, quite honestly, someone might come in and want to keep the whole parcel the way it is, and if someone's interested in buying the whole parcel, and that's potentially the way it is. This is just a plan for the trust to see what the potential is to, split this property up and sell it as it is. So, but Campbell, to answer your question, what's in red? So this rectangle here is 140 Old South Road.
Yeah,
It gets a property line right up the middle,
right.
frontage and frontage. And the frontage, the allowance to reduce to 20 feet in a commercial zone is a exception to frontage within the zoning bylaw. That's an allowed use. So you're allowed in a commercial zone, provided the lots stay in commercial use in perpetuity, to reduce your frontage to 20 feet.
So my other question is, because I am a little confused by the 34-foot, the black line that sort of comes across. So you're saying each of these is 5,000 square feet. You want to have a road-ish thing going between them. Does the square footage of the road, is that
No,
taken from?
there is no road. That was just that's currently a driveway right there. And what we showed is when we did the preliminary subdivision plan, we showed that as a proposed potential access easement that if through this property here, depending upon how this would work, you could potentially still use that cut through
Which
here.
keeps people spread out a little
Yeah.
bit.
Yeah.
No, yeah, I see that. It's very confusing. And then how does Lot 4 is going to access that? And the other lot seems to have the entry exit, the frontage that's open for travel. So it's confusing, and it seems like one lot is going to have that access in it, and the other one is going to have access to it, or is that being moved? It doesn't appear in this drawing that it is being moved to a shared position, but that's okay, because I can see where I get confused
Where it says
by all
brick
the lines.
apron.
Yeah.
Yeah. My understanding is that that area is going to service both of these
That would
long,
be,
narrow
I
lots
believe, you
if we
could have,
approve this.
you could make it a condition of any, I mean, although, obviously, if this came in, this could potentially come in as an A&R plan. But again, it wouldn't make sense to have another curb cut.
Right.
Number one, I have the building right here, and even if the building went away, to have two curb cuts in that particular area, to even get approved by the DPW would probably be difficult. It just doesn't make any sense. We're at the dead end of Old South Road, but having a singular access is the way that this would make sense to utilize it.
So to issue this, we have to find that it's not substantially more detrimental to the neighborhood to have it arranged this way with the reduced frontage. And I think what's materially different is only that you're going to have two lots going out onto Old South Road with whatever commerce is going on those two lots exiting there, versus before, we only had one lot exiting there. And so the question is, I don't think there's anything else that's materially different in terms of substantially more detrimental. Am I missing something?
No, I don't think you are. So the lot behind with the proposed way, has that been created?
By the same ownership.
It's same ownership. So could you conceivably have access to lot 4 from that way?
Yeah.
You could potentially access both of them from that way.
Okay,
Yeah.
okay, good.
So, I was talking about A&R, but I keep forgetting here, we're here for a special permit.
Yeah.
Phil, you could
we can mandate it.
issue this permit with a condition
Yeah.
that there's only a single driveway access.
I was just
Yeah.
trying to quantify, well, what
Yeah.
would be more detrimental?
Yeah.
And we know we have a very overburdened road,
Mm-hmm.
and the previous plan kind of funneled the traffic in a different way. And other than that, I don't think it really makes too much of a difference if they're long and narrow, or if they're chunked, if they're stacked that way with different exits.
There's a building in the way of access from Old South on lot 4, it looks like.
But even if that went away, I think conditioning it to a single driveway access is more than.
Fair, yeah, if you're happy with that, I'm
I
happy
think
with
it's more than
that.
reasonable for you to make that request or approve it with
Or
that.
one access off Old South,
Yeah.
and maybe we could we could limit to one access off of the proposed way as well.
So
So you
let,
could have two accesses to the lot.
well, I'm not sure we're talking about the same thing. So I would be thinking just to keep things the same and not have it be more detrimental, let's say the lot on the left would exit onto Old South Road and the lot on the right would exit onto the proposed way that we know already exists.
I don't have a problem with that either.
Well, that I would have, I mean,
You
there's no
don't like
reason
that.
why I don't think either one of these can't utilize the
The same, yeah, if
the
if
same
it's
access.
one, just one curb cut.
Just one curb
On,
cut.
on Old South, I
Correct,
think is,
correct,
and isn't
correct.
that what you're saying?
No, I was actually expecting there to be one curb cut, but my point is that if that one curb cut is being used by two separate businesses, and I'm not sure that this is really more detrimental
In
because
this area, I
in
don't
this
think it
area,
is.
it's the end of
Yeah.
the
It's
road
not.
and,
Yeah, I
and
don't
it's
think
gonna
it
go
is.
around anyway.
Yeah.
So I'm
It's-
not sure, but I'm just saying that if we wanted to keep it the same, we would have only one business using that one curb cut on Old South Road instead of two businesses. And we would say that we would keep the traffic flow by having the other long skinny lot exiting onto the proposed way. But I mean, at that area, I'm not sure it really makes sense.
Yeah, to be honest with you, I don't think it does.
Yeah, I mean, I think to that point, Hillary, is think if this was a commercial entity that was, cars were in, cars were out, cars
Yeah,
were
I
in.
was just gonna
They
say
come in the morning,
yeah.
maybe
If it
at
was like a
midday, they come
different kind
back,
of
they go out.
business.
It's a very limited
Yeah.
in and out,
It's the same
depending,
business.
for the
And we're-
uses that would.
Plus the other part of it is you go around one lot. So really, the delay of coming out of here and going around here
Yeah.
is like 30 seconds.
Yeah.
So I like the one curb cut. I know, I told you.
Yeah, do we all
Joe's-
Go get your own.
Joe's in traffic controlling.
I'm in control. Zip it.
No, and to Hillary's point, we're halving the size of the lot. So I'm not sure that it's really gonna be more traffic because the lot was bigger, it had more cars on it, it was busier, you half of it. The same amount of business can exist on this lot, it's just two lots now instead of one. So I don't think there'll be that much more traffic, if that makes sense to you. You understand what I'm saying?
Yeah, I mean, I
Yeah.
think I'm talking myself into it not being substantially
We're
more
getting there,
detrimental.
yes.
I
All
just
right,
wanted
there
to
you go.
make sure we
It's true.
examined it
Yeah.
from that, that's the standard we have to meet.
Do we have anyone online or anyone that wants to speak to this? No?
No, no hands are raised.
Okay, I would entertain a motion to close the public hearing.
So moved.
Second.
Motion made by Nat, seconded by Joe. Nat,
Aye.
Joe,
Aye.
Hillary,
Aye.
John,
Aye.
and I'm an aye as well. So, I guess the question is improvements, and I don't want to hold you to it, but I think that it's appropriate that we do something, that the applicant does something to improve the area somehow.
What did we do when we approved the subdivision?
It was just a preliminary.
Oh, it was a
plan.
preliminary plan.
Yeah.
Okay, I
So
was like,
should
I
we
know
wait
we
till the
talked.
subdivision to do
Yeah,
that?
so you can't
Yeah.
require, I mean, an applicant can volunteer them, but
Yeah.
you can't require
Yeah.
road improvements as a part of a special permit. You can do that through the issuance of the
Okay,
subdivision
so we'll
decision.
wait for the subdivision to do that. Okay, perfect.
And Paul, I'm bringing it up because before Dave said it, it's because of the timing of this whole area and how it's gotten to where it is. This is sort of like we're at the end a little bit.
Yep.
And we have this, this like gigantic hole actually at the turn that's been there for about 15 years. And then what Plumbers did, for that little piece is really, it's amazing. And I think,
Yeah.
I've never seen a cement road on Nantucket,
Yeah.
but it's actually,
Yeah.
it looks good.
I hear Nat offering to come out there with some boots and.
I'm just saying, I can't, it's good. I mean, because that's a private road still. I mean, that's why it has to, kind of happen this way.
I almost wish they had like a neighborhood association or
That's
some
what,
kind of
Joe,
pay into that.
when this all happened, the Coffin Pit, and we just couldn't unwind the situation at that time to make it be like we're talking now. But now we're at the end. But this is really more of just downsizing the existing business and putting something in place of some of it, and it's the same businesses,
Yeah,
same
right
kind
now
of
it's the same.
business.
It's a
It's not gonna be
basically,
really any different
No.
than it is now.
Yeah.
You know, or when it was busier, you know?
I think it's an appropriate use for the exception in the
it's a good plan.
CMI.
Yep, I agree, and this island's desperately in need of small commercial lots, so.
Absolutely.
Yeah.
Yeah, so, I would entertain a motion.
A motion to approve the application with the conditions, the two conditions.
So those are the two findings, and just to be clear, based on your discussion, we're adding the single access onto Old South Road condition, correct?
Yeah.
Yes, yep, because it still functions the way it does now,
Yep.
which is good.
I'm just curious about this note in our staff report about the applicant should clarify the future intended use. Well, we talked about
Yep.
that, and possible roadway improvements, but we can't talk about that now?
You can talk about it, but you can't require it, and I think the intent of that was maybe a larger conversation on what is your intent on moving forward with the subdivision application. Do you foresee that happening soon, not soon?
again, I'll
You don't
talk
know.
to Ben and Carolyn, and we'll see what their plan is to move with that, so.
Okay.
Because we were, July? Yeah, I think that approval was July 15th, so essentially I've got 6 months typically to, if they're gonna move to use it for any type of protection. I mean, this has been rezoned anyway, this has been rezoned to the CMI, so we're already.
Yeah, there's no
It's not
zoning
gonna
changes in
be
the
zoning.
foreseeable
No.
future here.
No.
We're not in the RC2, and we're trying to,
No, yep, that's right.
I think we might have been in the RC2, were we in the RC2 here? I don't know, we went from CM. Yeah, we were in
This
the
was,
RC2,
yeah.
yeah.
So
So,
we're finding that the reduction in frontage will not be substantially more detrimental because it's not going to materially change the traffic, and we're keeping the curb cut as a single curb cut, right?
Yes. You're fighting hard to justify this, aren't you?
I'm trying to get into the habit of documenting, you
Sounds like
know,
a
why
really
we
good
do
second
what
coming from
why we do what we do.
the key on that is, Hillary, is look at neighborhood, in the neighborhood, and then think of the neighborhood you're in.
Yeah, I know.
Okay, so, I'm sorry, we had a motion?
No, Nat made the
Nat
motion.
made the motion.
Hillary,
Hillary,
I added
seconded
some
a
things to the
comment.
motion
Okay.
and seconded.
okay,
Yeah.
seconded, okay, great. Motion made by Nat, seconded by Hillary. Nat?
Aye.
Hillary?
Aye.
Joe?
aye.
John?
Aye.
And I'm an aye as well.
Thank you all very much.
Thank you, sir.
Thank you.
All righty. We are on to Vito Petzeruzella. I axed that. 9 Nobody Your Way. Dan Malloy.
Evening again, Dan Malloy for the applicant. So we've got a property 9 Nobody Your Way. It's located in the R10L zoning district. And the applicant is looking to build a second dwelling. And in this zoning district, a second dwelling requires a special permit from the planning board.
Yep.
So we filed the application for the planning board. Obviously, that's why we're here. But for clarity, what we are showing is the overall intent of what the applicant's looking to do on the property, just so it's clear. We're not looking to surprise anybody. So the applicant is looking to redevelop their property, put up a second dwelling, which is the reason for the special permit, a primary dwelling, as well as a garage on the bottom right corner with an access ADU above it. So what we're trying to show you here, because I know there's been other projects in the neighborhood, this is everything they're looking to do. There's no surprises, maybe there's a fourth dwelling or something else happening here. So the special permit itself is only for the second dwelling. From a zoning standpoint, everything is compliant. We have more than adequate parking. Each dwelling requires 2. We have 8 spaces. We're actually required to have 4. So we're trying to put this together in a way that each dwelling has more than adequate parking, meets all the requirements of the zoning bylaw, doesn't surprise you with an ADU popping up at any point in time. This is it. This is everything we're looking to do. There's an existing single-family dwelling there right now with a garage. So they'd look to redevelop it and asking the board for the second dwelling special permit.
Dan, thank you for giving us a complete plan and no surprises.
It's all there. There's no surprise.
Much appreciated. Board members?
So that building up on the screen that's the existing building?
It's going
Or
away.
is that going away? This is gonna be new dirt?
This is all proposed.
Okay, all right,
Total redeveloped lot.
all right. I wasn't 100% sure about that because it's pretty close to the way.
The existing garage is in the bottom right corner, roughly where the proposed one is, and the existing house is about in the middle of the
Yeah,
lot.
okay, it is back a little ways, okay. Yep,
I had some questions about this because this zoning change was made relatively recently, like in the past 5 years or so. And one thing to consider is that we now have the ADU law. So when the zoning change was made, the secondary dwelling went to a special permit, and tertiaries used to be allowed, but they went to a no.
only a covenant.
Well, of course.
Yeah.
Right. But that's not what's being
I know, I'm
proposed.
just
So, so I'm not sure why we did that in this area.
I can tell you.
Yeah, why?
I can tell you, okay. Okay, so somehow, this little old area from the
60s or.
It's the Navy base days, that's what I always say. Was the lots were, it was in R20, but the lots were all under 20,000 square feet. And we never that never got picked up as a spot to fix the zoning until a little later on. And there's all local families live out here. But if we just changed it to R10 and just went, okay, bye, they would have a lot more, more, of course, that was before the ADU. I mean, obviously, everything's
Yeah.
before the
Yeah, yeah,
ADU.
yeah,
It's
yeah,
like,
yeah.
this is the new thing that you have to say every time you bring this stuff up. But by putting it in the same district as Mizzenmast made sense once staff looked at it. And that's basically, am I pretty close?
Yeah, and I think it's important to remember part of the requirement with special permit, which is why it was also implemented over in Mizzenmast, was the notification process. So
Yeah.
it wasn't, as I understand it, the fact that people were somehow
Well,
opposed
they
to
had the
second.
deed restrictions running
Right,
out
to
too.
second dwellings,
30
but
years.
it was, really meant to generate proper notice to the abutters instead of it being just by right.
Right, which is sort of a strange reason for a special permit, because it's supposed to be like special.
But over there, maybe I shouldn't have brought that up. The original approval in Mizzenmast in 85 was they can only have garage apartments, but it was in RC2. Every lot over there could A&R, every single lot. So it ran out in 30 years, and that's where the R10 Limited got crafted for that specific huge neighborhood, so there's no subdivision can happen over there.
Yeah,
But this was an oddball with the lots being under the zoning district size. Every single one was non-conforming. It was kind of peculiar. I don't know how that got missed on the list, but it wasn't pressing because there's nothing really going on over here, essentially. That's why, I think.
right.
So that's how this all happened,
So-
Hillary.
Thank you for that. So, if we're going to have something be a special permit, it has to be special, right? It has to, oh, sorry, Leslie, did you have something you want to say?
I just wanted to add a little more history.
Oh.
In this particular neighborhood, the neighbors didn't want to see significant character change.
Oh, good to know.
And they wanted to have a little more ground cover, but they didn't want to see a lot of subdivision. So that's how we came up with R10, because it was most consistent with how the neighborhood existed.
Right. So we have to have some real reason, something special, something different here's the thing, so now that we have the ADU is another dwelling, and they can have that. And so what would really happen to this lot if we approve this is that we would go back to what we had before, which was that it could have a primary, a secondary, and a tertiary. But because the ADU is the same size as what our tertiary is. And we might in the future adopt an ADU bylaw that allows for larger ADUs, which are kind of more the size of what many secondary structures are. I don't know, that's still TBD. But I think, especially given what Leslie said, this is a very year-round local, when we convey more development rights, we are making properties less affordable to local people. And this lot gets to have their primary dwelling, and they get to have an accessory dwelling unit. So I'm not inclined to give a special permit for a secondary. I don't see what would be special about it. I don't think it's consistent with the zoning change, what the neighborhood asked for. But I'm open to listening to other people's perspectives on that. Thank you.
I've never heard it phrased that way before, but.
Which part?
The special part of special. Never heard that yet, but it's okay. I think that we need to, go back to the Arts Unlimited, forget the ADU, and why we did it was, number one, to limit the tertiary as just, there would be 2 dwellings instead of 3, and to make the second dwelling a little more difficult. Not necessarily difficult, but more, okay, we have a say in putting, well, special, yeah. We can put it in a special spot on the lot. We can, depending upon what's already there, I think that that's what that means. It's sort of like the pools in Nantucket is a special permit, but they're still allowed. It's not by right, okay? Automatically by right. So I don't know what else to say. This ADU thing, this is what I was afraid of. This ADU thing is, you can't tell an owner that they're taking advantage of the ADU after we didn't know that this was coming. And we've removed the tertiary on purpose, except the covenant tertiary, and now that it's coming back as an ADU. They have the ground cover. I just don't know what the answer is to that. We're stuck. And we knew this, when the minute this started, this was an automatic, oh my God, what are we gonna do with this, right? Nantucket doesn't need the help from the state with stuff like this, I can tell you that. So I think we just proved that with the rentals, anyway.
I feel like the ADU just let out a bunch of rope with no real restrictions. So that's why I wish we still had the tertiary, because we could control this year-round, et cetera. But
Oh, that's a different.
I understand all that, but I'm just saying,
you're
so
right.
I also, I'm not really having a problem with this. I understand, he said the parking, the street, but I just wish we had a little more with the ADU, make it year-round housing.
I feel that there's a number of lots on this semicircle, whatever we call it, that have second dwellings already, right? So, and they will all be able to have ADUs. So we're punishing this one lot who hasn't created a second dwelling already, that they only get 2 dwellings. I think that, although in part I agree with you, Hillary, when you say, well, when development ratchets up, it makes it more expensive for people to live here and buy housing. At the same time, this neighborhood, just by the character of it, is housing. This is going to create housing on this lot.
Yeah.
It's not going to be short-term rentals. It's going to be housing.
Yeah.
And so for that reason, I don't have a problem with it. I think that it's tough to hold this guy, to punish someone who buys a lot that only has 1 house on it, when many of his neighbors already have 2 dwellings on a lot, and then restrict his ability to build, out like the rest of the neighborhood. So I don't have a problem with this, to be honest with you. From my perspective, I think it's appropriate for this neighborhood in this area.
And I also kind of just look at the plan, just see the footprints as in keeping with the neighborhood. I just feel that that's gonna kind of have that context, and the HCC will hopefully keep them on that line as well, so. But that's the other part of the secondary dwelling is that I always thought that permit was to make sure the 20%, and HCC make sure it's secondary massing to it. So really, I think that this is, I think in the end will be fitting within the context of the neighborhood.
Mr. Chair.
Yes.
You have John Kitchener up as well.
Okay. John?
Mr. Chair, yeah, just to add my point of view then, I agree with you that it doesn't seem fair to penalize this applicant when, in this neighborhood, there's already, lots that are doing exactly what he wants to do. So I would favor this application. Thank you.
Thank you. Do we have anyone in the public? You're always welcome, Campbell.
I just wanted to ask about this because what I'm hearing is that currently the lots that are in this area generally have 2 dwelling units or 2 structures.
2 structures.
Well,
Like
both.
a house and a garage?
We have one, we saw one last month that had their tertiary in their primary dwelling, so I think that one, and then they're getting an ADU, and I think there's already a.
But that was before the zoning change.
The other one on Nobody Way, they were protected, that they filed a perimeter plan under R20 zoning, which allowed them to by right get the tertiary where no one else in this neighborhood has that. They, everyone else just has the secondary, so that situation was a little bit different where they have 4 dwelling units now, where others are going to be limited to 3 with the ADU.
I can sort of see where the board's going, but it seemed to me that the purpose of zoning R10 limited was to restrict the amount of build out on a lot as far as dwelling units went. And so what I was hearing was that the lots already have, let's say, 2 structures. I haven't heard that they actually had a primary and a secondary. So maybe they have a primary and a garage or garage apartment or something along those lines. Is the rest of the neighborhood actually going to put in ADUs? Is this leading the way? I know there was the one that you were just speaking of from last month.
And they're putting in an ADU, and then this one's an ADU. I'm sure it's only a matter of time.
Well, right, but if we front load the matter of time, then that becomes a lot faster, right? Then everyone's like, oh, well, they're doing that, I can do that. But anyway, I see where it's going, which is fine, but I just wanted to point out the point 2 R10 limited was not to have a complete build out on the property. It was, sort of like on my street, we're all allowed 1 structure. Well, apparently now we can have an ADU with that. Whereas the other side of the street can have duplexes, et cetera, which we have quite a few of. So just in terms of the purpose of the zoning. And that to me is why it would be a special permit because of the limited, its current zoning. Therefore, this is a special case because they're asking for another building, to Hillary's point.
I think we're all trying to be fair here. I mean,
Yeah.
I'm certainly trying to be fair. I'm going through the property record cards. Some of them have secondary structures and some of them don't. So I don't think we can say that, they all, and very few have 3.
Yeah.
And only that one has 3. So this proposal before us creates 3 dwellings on this lot. And they absolutely get their second structure without even having to come to us. About the view that, oh, well, this is not going to be an STR, or, this is going to be this, that. We don't know. I had somebody tell me the other day that, they were having a conversation with someone who just moved to Nantucket. They're on Fairgrounds Road. They paid $5 million for the house on Fairgrounds Road. So we have to be very careful as a board about neighborhoods just slipping slipping away from what the people in the neighborhood said they wanted. And, when Leslie said, well, they wanted to make the zoning change because they wanted more open space, they wanted more control. I'm really uncomfortable with making assumptions, and I also don't see that there are a lot of what is in this neighborhood, if they put in an ADU, and especially if they wait and get a little bit of a bigger ADU, they're gonna look just like all the other buildings in the neighborhood, except that one that had a freeze on the zoning change. So, I mean, I know I'm in the minority, but.
It isn't that you're in the minority, Hillary. Okay, so now we're getting into beyond the weeds that Steve Welch and I used to talk about. If we had a crystal ball, would we have said, is this going to become Gray Avenue? I would have said, no way, okay? But it's America still. I know that some people don't think that, but it is. And someone buys these properties, unfortunately, they can make it new dirt, like this one. I don't know what the answer is. When the houses are built in the middle of the lot, because back when they were built for $2, no one cared. Now, if that building that's on that lot was built in the right location, this probably wouldn't be happening exactly the same way. It probably would be getting fixed up and they'd be putting in the secondary and the ADU. I mean, I'm just saying that as a sort of an example. I just don't have an answer. There isn't really an answer to what your heart is saying.
Well, it's
'Cause
not
I
my
understand
heart.
what you're saying.
It's not my heart. It's factual. There
Well,
are
okay,
other
but we
lots
can't-
with two structures. Oh, and Stephen wants to say something, but I also think we have to think about the property taxes, and if we have, this overdevelopment, what happens?
Let's also remember what this neighborhood is surrounded by on every side. Commercial neighborhood and C-Tech.
Yeah.
So this isn't where Campbell lives. This isn't Pine Valley. This is a residential area in the middle of commercial use.
I know it is.
That could be heavily developed.
It's,
So it just, for me, and I understand what you're saying, Hillary, I don't think this is the place to make that stand, is all I'm saying. I think that argument works a lot better in other neighborhoods than it does here, for me at least. I mean, Pine Valley, that's a good stand to make, but here, in this neighborhood, in its location, it's a harder one to accept. John.
Stephen Welch.
I'm sorry, Stephen Welch.
Hey, guys. A couple things. I'm going to back into it on David's comment, not to be disagreeable, but gentrification happens. And, there's a lot of areas where, not in Nantucket yet, where commercial areas are, some very pricey telephone exchanges. So I'm not suggesting that's going to happen tomorrow, next year, or in 10 years. This, I don't think, is going the way of Grave Ave anytime soon. But I think it's something to keep in mind, and this is all going towards a point, which there's an intermittent step before we get to. The other is a comment came up that, allowing more density or to that effect drives up prices for, in effect, year-round homeowners, workforce. I think that was the implication. I think that the really important aspect here is not more homes. It's, subject to having ample parking. It's controls on more homes. So what I mean by that is restrictions. And what I mean by that is restrictions to, no short-term rental in the particular unit that would be approved here today. So I guess that's the long way of saying, Mr. Chair, may I ask through you of staff whether there can be restrictions through the special permit in this particular zone with the particular conditions to apply that no short-term rentals would be allowed in the secondary dwelling unit. Thank you.
Yeah, I see no issue with that if the applicant is willing to agree to that.
I think before I get into talking about restrictions, I just want to bring something else to your knowledge so you understand what we're looking at. So we came here showing you what the applicant's full intent is, and there's a question on density. What we're not proposing, so something else to consider, is a restriction of 3 dwelling units on the property, period. And what I mean by that is, right now, there's a dwelling on the property and there's a garage. He could easily convert the garage to a garage apartment put up an ADU, have 3 dwelling units, and never come to this board as an alternative way to get to the same place. So we're trying to do this in a way to work with everybody, provide everything, but not be penalized for doing it in a clear fashion. So this could be done in a different way with no permitting required whatsoever. So we're trying to do it in a way that's very forthright and show you, because I'm aware of the other properties that's happened in the neighborhood. There are other second dwellings. I'm not sure if they've all been built yet, but there are other second dwellings, at least approved, at the end of the road, I think, someplace. And in terms of why the zoning was put in place, if it was, at least one of the reasons was to give the neighborhood, the people, the chance to get more of a public input on a second dwelling is great. There's no one here.
That's true.
Well, but it was this undersized lot for the zoning that was there. Very unusual.
But, I mean, normally if one of the things we look at here is if the neighbors are objecting, then it's either restrictions, full pause, scale back, what can we do? And from the neighborhood standpoint, there's no objections. So I'm just mentioning that as a cue to look at what we're trying to do, how we spread it out. We're putting privacy screening on one side of the property. We have double the required parking on the property. So I think we're meeting and exceeding everything that would normally be asked for before we even talk about possibly restricting something.
I have one question for you, Mr. Malloy. The picture on page 6, why does this proposed secondary dwelling look so much bigger than the primary dwelling?
That's how they classified the buildings. They don't have, so on the way the zoning reads, the primary and secondary have to be 20% different in size, but there's no differentiation in terms of which one is which. It's a wording.
So Dan, am I hearing that you're not interested in?
Well, I don't think I'm interested in giving the restriction, and if that's going to be a full holdup on the second dwelling, I mean, I'd have to probably get a continuance and just confirm that the owner is actually, I don't know right now that I can say that's a guarantee.
In the end, the ADU, we haven't gotten there, but that will probably be restricted from STRs, hopefully by next town meeting. And
The ADU will be restricted?
now that we have it in our bylaws, we can restrict it.
Yes. Yes, protected use EDUs can be restricted from short-term rentals now that we've defined what short-term rentals are.
Yeah, so we have the ability to do that.
We're certainly fine with no short-term rentals. That's not, I mean, we're certainly fine with restricting no short-term rentals on the whole property.
Oh, I think that's what
I
we're
think that's
asking.
what he was saying.
Yeah, that's what I was
Oh,
saying.
this isn't intended as short-term rentals.
Yeah, I didn't think
so
it was.
That's fine.
No, it doesn't seem to be, and it's not. in the
Property is
area.
going to lend itself to more affordability, just honestly, as you've already said, due to its location. This isn't,
To me, this seems like it's gonna be housing. It's gonna be long-term rentals. It's gonna be employee housing.
I've been down this street. I know what these properties look like, and I don't think the people on the street want to see really huge parking lots, but no one is here, and presumably they all got notified, so I don't feel like I can speak for the people.
well, and I'm not going to speak for an HTC application, but I know it's been before the HTC already. And my understanding is they're waiting on seeing this revised plan that you're looking at, because they had asked for buildings to be moved. And my understanding is from an HTC standpoint, they're ready to approve it.
Right.
And the only reason I mention that is that would have involved a public process as well. And I'm not aware of any objections from anybody at that time either.
Yeah, it's just, well.
Yeah, so, right. Who do we
It
have?
looks like Stephen Welch.
Stephen Welch has his hand up again.
Stephen, welcome back.
Hey, thanks, Mr. Chair. Sorry, I wanted to make sure my mic was on. I'm a little bit confused. That's nothing new. I just want to get clarification Dan, through you, if I may. Dan had said that they can do this anyways without the special permit, or did I mishear him?
No, that's what he said.
It can be done differently.
Okay, so I'm not sure how, because if you've got 2 dwellings on a lot, one of them needs, under this particular zone, R1011 zoning district in this particular area, it needs a special permit. So that unless there's something, is there some other way to accomplish this?
Stephen, a garage apartment in R10 Limited does not require a special permit. So currently, the plan has the garage apartment as the by right ADU, but if you were to redesign maybe some size of structures and swapped what they're called, this could be permitted by right.
But it would be.
Right, hold,
Yes.
please, sorry, but it would be size limited with
Yeah.
respect to the new dwelling that's currently be considered a secondary dwelling, because it would have to be an ADU, is that correct?
Right, the second dwelling would have to be this ADU, right? The cottage size, cottage
Okay.
style structure would be the ADU, and the garage apartment could be constructed subject to ground cover limitations.
Okay, so that was for my own edification. I just wanted to make sure I understood. But it sounded to me like Dan came around with, there's no concern with restricting short-term rentals on this, which is what I was suggesting. So if that's the case, and I'm not voting on this, but that would settle my concerns. Thank you.
Yep. Yeah, so, anyone else online? I think it's time for us to.
No one's online.
To make a decision here, so I would entertain a motion to close the public hearing.
Motion to close the public comment.
Second.
Motion made by Joe, seconded by Nat. Joe?
Aye.
Nat?
Aye.
Hillary?
Aye.
John?
Aye.
And I'm an aye as well. As to the merits, folks.
Make a motion to approve with the findings and the conditions, adding a seventh to the short-term rentals?
Yes.
Is that okay?
7th or 8th?
I think it's 7.
Now,
Well,
can we do that on the
we got
whole
one and then we
property,
have one point.
Or do we have to do that just on a special permit second dwelling?
I would suggest just the second dwelling.
Yeah, I think we don't have a choice.
Okay,
Yeah.
but, all right, well.
So no, it's fine, just on,
Yeah.
no
Because
short-term
we're
rentals
only,
in the
I
second
know,
dwelling.
we're actually what we're here for. He's showing us the world. but
Yes.
Technically, we're voting on that. I know, I'm getting lost in the great plan.
Yeah.
Okay, got it.
I will second that amendment.
Oh,
Yeah.
okay, motion made by Nat, seconded by Joe. Nat?
Aye.
Joe?
Aye.
Hillary?
Aye.
John?
Aye.
And I'm an aye as well.
Thank you.
Thank you,
With
sir.
the spirit of the property.
We just enjoy putting you through the ringer, Dan. All righty.
Thanks, Dan.
We are on Born Wild LLC, 5A Rosebud Lane. Is Mr. Gasparo online?
Yes, I'm bringing them over right
All
now.
right.
This is beautiful.
Maybe get some water.
Yep.
This is classic.
Yep.
He's on now.
Welcome, Art.
Thank you, Mr. Chairman. I'm before you tonight with a special permit application for a contractor shop within RC2. And this is for a local caretaking business. And I will say that I think there was a little bit of confusion that happened. And also here with me is Attorney Jennifer Cohen. And we both filed applications. So this one, you have the site plan that was filed using the architectural plan. There's also a site plan that I would be happy to share if you would like me to, that had been filed, which has drainage and just a little bit more information.
All right, I'd say share your version.
Okay, thank you. So they both show the same structural elements, but we added the parking spaces, and then stippled in the crosses, we showed what would be open space, and included the calculations for providing the 20% open space. We also showed a little bit more of the infrastructure in terms of sewer connections, floor drains using oil, gas, water separators. We understand you would likely require a water quality certificate. And so we've shown that catch basin and water quality inlet that would happen in the town water service, as well as the structure itself. We've also seen the staff report and are amenable to the conditions with respect to an additional landscape plan and the condition that the trash be taken care of on a regular basis. With that, we'd be happy to address any questions or concerns or that you might have.
Board members? Yeah. Board members, questions, concerns?
Close public,
Huh?
close public comment.
Do we have anyone public?
No, no hands are, hang on.
Oh.
Deborah Holgate.
Oh.
Welcome, Deborah.
Hi, I just want to say that as a butters, my husband, myself, and our two children, as presented, we like the plan. So we have no negative comments.
That is a breath of fresh air right there. Thank you. All right, anyone else in the public? All right, I'd take a motion.
Motion to close.
Public comment.
Public
Second.
comment. Yeah.
Motion made by Nat, seconded by Joe. Nat?
Aye.
Joe?
Aye.
Hillary?
Aye.
John?
Aye.
And I'm an aye as well.
Thank you.
Well, we're not done yet, Art. Don't run away. As to the merits.
Based on the neighbor's recommendation.
Yeah.
Second?
I don't remember the last time that happened. So we have a motion.
Second.
We can do the landscape plan through staff,
Yeah.
correct?
I think that was that already? I think so.
Yeah.
Yeah.
Second.
Who made, Joe made the motion?
Made the one.
Okay, motion made by Joe, seconded by Nat. Joe?
Aye.
Nat?
Aye.
Hillary?
Aye.
John?
Aye.
And I'm an aye as well. Now we'll see you later, Art.
Thanks again.
Is he gone already?
Thank you.
You're welcome. All right, other business. NPNEDC and the Alphabet Soup Roadshow, ELHLC, ADU Roadshow, November 20th, 2025 via Zoom. Next regular meeting is.
What's the roadshow? Is that where we get to show off what we are thinking? And
Yeah,
get their
so it's just
comments?
kind of an open house listening session. EOHLC is going to be there to answer questions. I will post a planning board meeting. I encourage you all to attend. I think it'll help us in formulating our local bylaws. And of course, any members of the public, welcome to attend as well. And I do have the link for that. I'm sorry for not including it on the agenda, so I'll circulate that to you all. It'll also be
Send, like, a
posted on the
calendar
posting.
invite with the
Yeah,
link in it.
I can do that.
That'd be great.
Yeah, it'd be
The
great
best.
to get the HDC special notice on that too.
Yep.
Is Steven still here?
Sure, yep.
Yeah.
Can we have a
Oh,
moment,
yes.
like 10 seconds for my
Yep.
birthday? That'd be great.
Wait, it's your birthday?
I'll be turning 60.
No.
Yeah.
What's Steven's number?
Yeah.
I told you I was in.
All right, next planning board meeting, Monday, December 8th. Staff, you guys are the best. Thank you very
Thank
much
you.
for all you do.
Thanks, everybody.
Accept the motion.
Motion to close. Adjourn.
Adjourned.
Yeah.
Sorry.
Second.
Motion made by Joe, seconded by Nat. Joe?
Aye.
Nat?
Aye.
Hillary?
Aye.
John?
Aye.
And I'm an aye as well. Thank you.